urgent matter, Lordship. My Lord, matter is a pending matter, Lordship, regarding your Lordship to the promotion to the post of headmaster, Lordship. My Lord, a similar situated person, Lordship, they have got the order.
What do you want?
Lordship, day after tomorrow, Lordship.
Day after tomorrow, not possible.
Lordship.
Next week, any date, take from him.
12 December.
Yes.
Lordship, for mental Lordship, on 12th Lordship, I have another matter in another court, Lordship. Can it be Lordship prior to 12th Lordship? Otherwise, the Lordship, my Lord,
11. Yes.
Motion matter is regarding the departmental proceeding, identical to the similar matter, where departmental proceeding has been going on as well as a criminal proceeding. The findings have to come out without any basis. That's not any day my series will be terminated. We filed this matter wait upon 18 months. It has been also numbered. Pray for matter may be listed more from motion.
Motion matter.
Yes.
To the consent of the other side, I beg to mention item number 18, Your Lordship. In this matter, the engaged counsel, Mr. Ayazika, is unwell today.
18.
18, Your Lordship.
On the pair being made by Mr.
J. Das for respondent number 5.
J. Das, learned counsel for the respondent number 5. With consent from the other side. The matter stands adjourned to be listed after
Vacation.
after vacation. When it was made part third? Part third also was good. Part third. FAO. FAO na? I don't know. 18. Okay. To be listed after
After the vacation, Your Lordship.
after vacation. Okay.
Deeply
Yes.
obliged.
Old matter, Your Lordship. Pension.
Of which year?
24 years.
24.
Or admission. 2 matters.
Before vacation, not possible. After vacation.
May I please, Lordship? Lordship, I beg to mention a requisition for listing, Lordship. So some urgency is there, Lordship. The person is suspended, Lordship. So can it be taken up on Monday, Lordship, 8th of December?
Next Monday.
Monday, this next Monday.
10th. Tenth.
Right.
For the completion of the appointment, pending a matter, the Lordship will make a direction on 18th 2025 for listing after 4 weeks. But that matter is just regarding this matter, I was several petition before the registrar also.
So when do you want? When do you want?
I for 5th of December.
5th December. Under which category? Which column?
Completion of the appointment.
Motion admission hearing. Conditions. On 12 December.
May I please, Your Lordship? I wish to mention for analogous matter, my lord, in the column of admission, any date in the next week, my lord. It was last posted on 12th,
Take
11th
a
of
date from him.
Lordship.
Take a date from him.
Update.
With the consent of other side, I beg to mention item number 3 also.
Item number 3.
The learned engaged counsel is out of station. It might not be adjourned for the.
Mr. Your good name?
Mohammed Terek Manipur.
Learned counsel appearing on behalf of
AW Ahmad Terek. Mr.
learned counsel for the petitioner. You inform the other side?
Yes.
With consent from the other side, press for listing the matter after
Lordship, it may be fixed on 16th December.
16 may not be possible. After the vacation.
Date may be.
On 9th January.
Lordship.
May I please, Your Lordship? Lordship, I beg permission for listing of a repetition. That was filed on 2011-25 on 4 December.
Not possible.
17th December. My lord, this is the constitution of illegal ascendancy. We have filed this on 24/11, not listed. It may kindly be listed day after tomorrow.
Not possible. Next week,
Next one.
next week. Yes,
May I please, your lordship, with the consent of the other side, I beg to mention item number 5.
5.
We will file affidavit in replay. Lordship may fix the matter after vacation.
After vacation. Mr. Your name, please?
A is Molla on behalf of Islam, legal aid
Learned
counsel.
counsel, appearing on behalf of Mr. R. Islam, learned legal aid counsel. With consent from the other
Lord,
side, first
may
for listing the
fix
matter
it.
after vacation, bear a lot. Rest is list the matter after vacation.
Obliged.
Item 4, motion. Item number 20.
Today at 2 PM. Listen.
May I please, your lordship? Kindly, matter may be taken up.
Items for admission, item number 1. Alternate.
If it pleases you, lordship, already informed your lordship earlier, the petitioner counsel, your lordship. This matter was raised by Active Khatinier, and he was not able to attend court, your lordship, due to some personal difficulties. Your lordship, he was very much there yesterday also, your lordship. So I pray for adjournment on behalf of Active Khatinier. Can this matter be listed after 2 weeks, your lordship?
Why after 2 weeks?
Or 1 week, any date may be given, your lordship.
Yes, any
May
objection?
it please, your lordship? It's already delayed for 13 years, your lordship, my matter. And the rule is already complied with. It is clearly reflected in my affidavit in opposition, your lordship.
Your lordship, just 1 week.
Your lordship may kindly fix the date in this month, your lordship.
Okay.
It will be convenient.
It does learned standing counsel, no, learned counsel appearing on behalf of Mr. N.J. Khatania. Learned standing counsel for the respondent in elementary, secondary education department. With concern from the other side, press for listing the matter after a week. Bear a lot, SSL list the matter on.
18 and 18 will be
December.
different. Much obliged.
Item 2, alternate.
Thank you, sir. I am from Monwara Begum, my name. Which matter is there?
Item number,
1. Which matter is, I am from Monwara Begum.
item number 1.
Yes. IF5.
Not yet completed, your lordship. I'm the main petitioner, I'm the original petitioner, and you're coming for
Monwara Begum.
Mohara Begum. She has filed a impleadment petition, your lordship. That was not impleaded, and the earlier.
I think also it's. I can not.
Uh-huh.
There is one, I think, there's a fit for that.
I for what purpose? I for
What's it? Okay, your number?
A number, my lord,
1773.
1773.
Made the your lordship.
yes.
The earlier date, the honorable court directed the interlocutor applicant to move to the education tribunal where my case is for other crucial aspects of this issue, which is pending before the educational tribunal, your lordship. Honorable court directed the interlocutor applicant to move their impleadment petition there, and it was already dismissed on 26th of November. That was not allowed by the learned educational tribunals. And if your lordship permit me, then I will place in the ensuing date that order.
Okay, we will issue notice. Heard, Mr.
A.K. Das, my lord, on behalf of SC Viswas, my lord.
Learned Counsel appearing on behalf of
SC Viswas.
SC Biswas, Learned Counsel for the applicant. And also heard Mrs. M.A. Uza, Learned Counsel for the respondent, opposite party. Number 1. Anybody for the state respondent? Inspector of School. Miss P. Das, Learned Standing Counsel for the respondent team. Respondent number
Implement petition. Private court double this.
respondent number 5.
Your Lordship,
Inspector of School, Dhubri.
Your Lordship, earlier, other occasion, Your Lordship, this implement petition has not been allowed, Your Lordship.
When?
Your Lordship, earlier occasion, Your Lordship, this matter has held up, Your Lordship, for implement of party.
Where is the order?
Respondent has not been allowed, Your Lordship, at the Your Lordship.
Maybe we will decide the matter later on. Today we are issuing notice in this IA. For respondent number 5. Inspector of School, Dhubri. And madam, you are appearing for respondent number 4, 3 and 4. Deputy Commissioner? 4. And disciplinary authority, secondary education, Assam 3. 3 and 5, Ms. Peters. Ms. Fukon for State of Assam, you. For respondent number 2 and 4. And School Management Committee,
To private respondent.
how is School Management Committee is a private respondent? Who constitute the School Management Committee? The Inspector of School?
I am, Your Lordship, I am appearing for Inspector of School, but I would not be, Your Lordship, representing as a headmaster or any other.
This interlocutory application under Order 1, Rule 3 of the Code of Civil Procedure. Read with Section 151 of the Code of Civil Procedure is preferred by the applicant. Namely, Monuara Begum for implement. For her implement in the present rate petition, in the rate petition number 2003 of 2024. Issue notice returnable. Copy next that rate petition of the 18, returnable on 18th. However, no formal notices required to be issued since the respondents are represented by their engaged counsel. However, extra requisite copy of the application will be furnished to them during the course of the day. Place the matter on 18th December along with WPC number 2003 of 2024.
Bless me.
Yes, Mr. Das.
Malad has already heard the petitioners, Malad.
Hmm.
Kindly have the prayer manual at page 26. And find with the prayer manual.
Yes.
Their main prayer is my lord. Is setting aside and passing the impugned proceeding or report dated so and so of Pandit Deendayal Upadhyay Adarsh Mahavidyalaya regarding election of respondent number 8 for appointment the post of assistant professor of Bengali in the state college. Then my lord, governing resolution they are challenging and the impugned order passed by the director. And second, and the another prayer is to appoint the prayer B, to appoint the petitioner in the post of assistant professor in the department of technical matters. Basically, they are selecting the selection of the respondent number 8 by the selection committee of that particular college. Kindly have.
But the respondent number 8,
Yes, ma'am.
she has not contested the case.
He has not come forward.
What is your stand?
My statement, my lord, but earlier also, the petitioner has challenged the selection of the private respondent by way of the petition 2191 2024, which is at page number 149. 24 one.
The next are 24.
Page 149.
Yes.
Then my lord, 150, page number 153, the fact, I'll just read a few lines, my lord. Page number 153, para 3. The petitioner hearing by way of instituting the present proceeding has essayed the selection of the respondent number 15. That is, my lord, the private respondent hearing. By the selection committee has constituted for the Pandit Deendayal Upadhyay Adarsh Mahavidyalaya for appointment as assistant professor in the department of Bengali under PWD category on so and so. The petitioner has also essayed the approval as granted by the governing body of the said institution to the said selection as made in respect of the respondent number 50 by resolution number so and so adopted in its meeting held on so and so. So I'll not go to the other side. Now then kindly come to page 156, para 9. But the learned code has observed and held classes. Para 9, as evident from the instruction as placed on record by the learned standing counsel for the higher education department, the proposal as submitted pertaining to the appointment of the respondent number 15 hearing, it is presently pending consideration with the director of that should be higher education, Assam for examination. This court is of the considered view that the matter having not been given a final consideration by the director of higher education, Assam, the present proceeding is to be held to be premature. However, considering the grievances raised by the petitioner as well as the alleged level pertaining to the election of the respondent 115 against the post inquisition, this court hereby directed the petitioner to submit a detailed representation before the director of higher education of Assam and herein highlight with materials the inconsistency and or irregularity in the selection as made by the selection committee of the college in question in selecting the respondent number 15 against the post of assistant professor in the department of Bengali under PWD category. Then 10-6 legislation. Then para 11 next page. 157. The director of higher education Assam.
So, Mr. Das, you say earlier, though the petitioner has challenged the selection of respondent number 15, the court has not adjudicated the matter.
Well, then since the director is yet to take the final call.
Yes.
That's why this petition was held that
Yes.
petition was premature, my lord.
Yes,
Even now also, my lord, the director is yet to take the final call.
okay,
I'll show, my lord. Why this, one of my ground is that this petition is premature. That's why I'm showing this, the designation. Then, kindly have the para 11 and 12, my lord. The Director of Higher Education Assam, on receipt of the representation from the petitioner, along with a certified copy of this order, shall fix the date for hearing in the matter and issue notices thereof to the petitioner, as well as 15 and college authorities requiring their appearance on the date so fixed. The Director of Higher Education Assam, upon considering the contentions as made by the petitioner hearing in the her representation, has now submitted by her, and upon hearing the petitioner, the respondent number 50 as well as the college authorities proceed to dispose of the same by way of issuing a sticking order containing the decision as may be arrived by the Director of Higher Education Assam, along with the reasons basing on which decision was to be arrived at. But that was the direction given by the to dispose of the.
this direction was issued in the year 2024
Yes, madam.
on 29/4/2024. Why the director has not disposed of the representation then?
Dispose of, madam.
When?
Kindly see, madam, page 159, page annexure 25. The petitioner filed one, after this order, the petitioner filed one representation, page 159, annexure 25.
Thereafter, what happened?
Dear madam, kindly see the prayer of the petitioner, which is at page 169. Prayer of the representation. 169. Under the facts and circumstances as has been mentioned above, I accordingly most humbly pray that you may be kind enough to call for the records, and on perusal of the records relating to the selection of the candidates, particularly the comparative statement that is so that was prepared by the selection committee, and the advertisement that is so that was issued by the authority concerned, and after hearing the parties, be pleased to appoint me to the post of assistant professor in the Department of Bengal, College, in person to the advertisement that was mentioned. It was in representation, their prayer was to appoint the petitioner in that post matter. And accordingly, if you know, the order was passed, it is at page number 182. Annexure 27, the last page.
Yes.
It says, second paragraph. Whereas Dr. Onama Roy, the petitioner was heard and reveals being that her PhD degree was not accepted by the selection committee for the post of assistant professor, Department of Bengali of College. The selection committee had stated in its report, PhD is not in concerned subject as per DHC guideline, as so did not have net slate at the time of interview. She could not pass the interview, hence the petition of Dr. So has been rejected on the above ground, and the order of the Honorable High Court is complied. By way of this sitting order, my lord, only the candidature or the candidature of the petitioner has been rejected because the petitioner does not qualify the requisite qualification for that post matter. If this impugn order does not finalize the selection of the private respondent, which the director is yet to take a call. Because the procedure is, my lord, when the selection committee or college authority send a proposal for approval, my lord, the director, after verifying all the documents, director has to take a call, and if that the director can either approve or reject the proposal. So here in this case, the director is to take a final call regarding the appointment of the private respondent. In that regard, my lord, I want to rely on decision of the ordinance, my lord, where while relying upon some other cases my lord, of this honorable court, the court has elaborated the method and the position in such kind of cases, my lord. As we rely upon, my lord, may kindly mark the paragraphs, my lord. Para 4, 6, 7, and 8. Para 4, 6, 7, and 8. Para 4 talks about the method of recruitment. My lord, in para 4, my lord. The direct.
Yes.
If my lord allow us, I can read.
No, not necessary, not necessary. So according to you, the director has not yet taken a final decision in respect of the selection of the respondent number.
And since the petitioner is challenging in the selection of the respondent or private respondent, that's why one of my argument is that this petition is premature. Now regarding selection of, regarding challenging the impugn order, whereby the director has said that the petitioner is not qualified for that post and her candidature was rejected. Kindly have the advertisement for medals. Page 124, annex 9.
Page number
124, annex 9. Here, my lord, the petitioner as well as the private respondent are participating in serial number 6, my lord, Assistant Professor Bengali. Reservation PWD, table, my lord. Number of post 1. Advertisement is dated 27/2023. Top right corner, my lord. 27/2023. And the last date for submission of application, my lord, terms and conditions 10. Two set of filled in prescribed applications, my lord. Second last line, my lord. Within 15 days from the date of publication of this advertisement. So within the 15 days will come to an end on 4/8/2023. So the petitioner has to qualify or obtain the requisite qualification on or before 4/8/2023. Now, what are the qualifications, my lord?
The advertisement is updated 28/7/2023.
23.
So the last date for submission of application form was
Within 15 days from the date of publication of this advertisement, which comes to an end on 4/8/2023, 15 days from 20 July.
Yes.
Develop terms and conditions to apply. One, educational qualification as and selection procedure will be as per the government office memorandum by number so and so dated 29/1/2022. This will be important, my lord. Then then 4. Candidates have to acquire qualification as on the last date of submitting application form that I have shown, my lord. Then the guideline, my lord. The OM, which talk about in terms and condition 1, my lord. This is just page number 120. The previous annexure, my lord. Annexure 8. Which is eligibility qualification, very important. Our concern is with 2 and 3. 2 is beside the candidate must have cleared the national eligibility test conducted by the ETC or similar test accredited by the ETC, like SLATE and SATE. So one of the condition is that the candidate has to qualify NATE and SLATE. However, P says if the candidates who has obtained PhD degree, they are exempted from NATE SLATE. Notwithstanding anything contained in subsection 1 and 2. The clause UGC regulation candidates who have a PhD degree in accordance with the University Grant Commission shall be exempted from requiring the minimum eligibility condition of NATE SLATE and SATE. So one of the needed qualification is that NATE SLATE, either NATE SLATE, or if the candidate is having PhD, then NATE SLATE is not required. Here in this case, my lord,
Yes.
here in this case, the petitioner participated on the basis of her PhD degree. Kindly have page 119. Previous annexure 7. This is the certificate for clearing NATE exam, my lord. Finally, see the middle paragraph, the date of eligibility, my lord. The date of eligibility for assistant professor is the date of declaration of UGC NATE result, that is 18/1/2024. This date is subsequent to the date of the advertisement and the last date of submission of application.
So on the date of filing, last date of filing of application.
4/8/2023, my lord.
Yes.
Advertisement was of 27/2023. 15 days is 4/8/2023, and the petitioner acquired NATE on 18/1/2024.
After
the last date of
filing of application.
So the petitioner doesn't have NATE or SLATE qualification on the date of submission of the last submission of the form. So only remedy is through PhD. Only remedy for the petitioner to participate in the selection process is through PhD. Now, let us add the PhD degree certificate. I will kindly have page 35. Page 35 is the
Yes.
master degree certificate, my lord. It says Master of Arts, middle, my lord, Master of Arts in Bengali department, my lord. The petitioner has master's degree in the department of Bengali. Then, my lord, kindly have page 37 annexure 5. This is
Yes.
my lord. Notification regarding PhD of the petitioner, the second serial number 2. Roy. Department, my lord, cultural studies of Bengal. Although the petitioner has done her masters in Bengali department, but her PhD is from the Department of Cultural Studies, Center for Interdisciplinary Studies. And my lord, the next column is title of the thesis. Title of the thesis is, my lord, Cuisines of Sylhet, a socio-cultural study on Barak Valley of Assam.
But what was the requirement in the advertisement?
Yes, my lord, this concern department is, I'll show, kindly have. Advertisement, my lord. Kindly see the page 122, my lord, the guidelines. The OM which was followed on the advertisement. 122, the last table, point number 5. PhD in the concerned subject from UGC recognized university. But here in this petition, the petitioner has suppressed few facts, my lord. All over in the petitions, the petitioner has says that they have, the petitioner has done her PhD in Bengali department and regarding history and evolution of Bengali language, my lord. Kindly have page 6, para 6, my lord. Very petition, my lord. Para 6 says, the petitioner thereafter was awarded with the PhD degree by the Mahatma Gandhi University, Meghalaya, for her thesis titled as the socio-cultural study on the Barak Valley of Assam, particularly the history and evolution of Bengali language in Barak Valley. It said that the thesis was particularly related to the history and evolution of Bengali language. Then, my lord, in another paragraph, page 20, para 32. Below, my lord, from below, I think 10 or 12 lines. The PhD degree, my lord, got it from this. The PhD degree was issued to the petitioner by the Mahatma Gandhi University, Meghalaya, which was considered by the University Grant Commission, and the thesis title as the so-and-so prima facie reveals that it was regarding the history, evolution of Bengali language in Barak Valley and Sylhet district of Assam. If my lord got it, my lord.
Paragraph number?
32. 32, 11 line from below, my lord. Para 32, page 20. From bottom, my lord, 11 line. The PhD degree was issued the petitioner by so-and-so university, which was recognized by the UGC. And the thesis title so-and-so prima facie reveals that it was regarding the history and evolution of Bengali language in Barak Valley and Sylhet district of Assam. This was the statement made by the petitioner in petition. Whereas, my lord, kindly have page number 40A. I told her what was the case is about.
Yes.
40A is my lord the title, Cuisines of Sylhet. Regarding food, Cuisines of Sylhet, a socio-cultural study on Barak Valley of Assam. Then my lord, kindly turn to page 45. Introduction part. It says the preparation for food and food craft by man is one of the most so-and-so, my lord. It's talked about the introduction part, also talk about the food. Then, my lord, kindly come to page 52. This is important, my lord. Aim and objective of the study. The aim and objective of the study was fundamental point of the proposition of the study is to show and track down the food of Sylhet, exploration of knowledges and practice of cooking in Sylhet style in another objective of the study. Then thereafter, need minor. This is the other aims and objective also. Minor will see it's all related about the food of Sylhet. It's not about Bengali language and anything, minor. So the selection committee, minor, rightly held that the PhD done by the petitioner was not in concerned subject. Now the selection committee, minor. The selection the other side on earlier date, my lord, raised question about the selection committee also, the composition of the selection committee. But the selection committee was as per the guideline. And we have one, page number 120, again, page number 120, connector 8, the office memorandum. Below it says that selection committee. The selection committee for the post of assistant professor in colleges, including private colleges, shall have the following compositions. The composition is, my lord, the chairman of the governing body of the college or his or her nominee from among the members of the governing body to be the chairperson of the selection committee. Second, the principal of the college. Third, head of the department of the concerned subject of the college. Fourth, nominee of the vice chancellor of the affiliated university, of whom one should be a subject expert. In case of college notified or declared as minority educational institution, the chairperson of the college will nominate persons from a panel of 5 names, preferably from minority communities, not that. And 5 is subject expert, not connected with the college, to be nominated by the chairperson of the governing body of the college out of a panel of 5 names recommended by the vice chancellor from the list of subject expert approved by the 11th statutory body of the university concerned. Then this is important. Point number 6. The other side once raised question regarding presence of one member of the selection committee who is not from Bengali department and was from the department of Manipuri. So the question raised that what is the need of the presence of that person regarding Manipuri? What will be his knowledge regarding the subject of Bengali? The presence is required because 6 says, if any of the candidates belonging to SC, ST, OBC, minority, women, differently able categories, and there is no member representing these communities in the selection committee, the vice chancellor shall nominate an academician representing SC, ST, OBC, minority, women, differently able categories. And my lord, remember that this advertisement was published person for the post of PWD, reserved for PWD, my lord, with disability. So that's why that person was needed there. And kindly, page number 146, the selection committee members. Page 146. This is the proceeding of the selection committee meeting, which was held on 29th of August 2023. The second table, member, signature of the members of the selection committee says that one chairperson was there, and one secretary there from the state college. Basis nominee was there. Basis nominee comes subject expert. Here were three subject experts matter. Basis nominee comes subject expert. One Professor Bella Das, Department of Bengali, Assam University, Silchar. Then subject expert was Dr. Munmun Bhattacharjee, Department of Bengali, DC College, Silchar. Third subject expert was Dr. Sumita Ghosh, Department of Bengali, Hasar College, Silchar. HOD was present. He is also from. He is from Bengali Department. Dr. Debjani Devnath, Department of Bengali, and for PWD representative, that's member from Department of Moniguri, Silchar University. So there are subject expert in that committee, as per the guidelines. And what was held by the selection committee comprising of the subject expert, my lord, it will find the next annexure number 147, annexure 23. Pilot, let's see. Page 133, my lord, the comparative status of March. Page 133.
Yes.
Below, my lord, the remarks for Anamaya Roy. That is the petitioner is not in concern subject as per EC guidelines. Now, my lord, the question is, when the selection committee comprising of subject experts, after verifying all the documents of the petitioner as well as the other candidates matter, decided that the PhD required by the petitioner is not in concern subject, whether this honorable court exercising jurisdiction under 226 has power to review that decision of the subject expert or academic expert. In this regard, I want to rely upon certain decisions, my lord. Kindly mark the paragraph, my lord. I will read all those. Para 6.
Section
9 and 3. 284.
Yes.
Para 6. 27. 28. 29, 30 and 33. 6, 27, 28, 29, 30 and 33. Here also, my lord, the question arises regarding equivalency of two subjects, my lord. I'll read para 29, my lord. Or from para 27. However, we agree with so and so that since academic experts have regarded political science and public administration to be one discipline, it is not right for this court to sit in appeal over the opinion of the experts. Mr. So and so learned counsel has pointed out that for the post of reader and lecturer in, I'm reading 28, madam, 27, 20. In public administration and political science, a large number of advancements have been made in the respondent university as well as in the higher education department of so and so. Political science and public administration as one discipline. There are a large number of persons who have a MA and PhD degree in political science and are working as teachers in public administration department and vice versa. In so and so, 2001 SSC 546, following its earlier decision, the constitution bench of this court, the University of Mysore versus so and so, this court observed that normally it is wise and safe for the courts to leave the decision of academic matters to experts who are more familiar with the problems they face than the courts generally are. A similar view has been expressed in several decisions in this court. Students of Malone, the decisions were given. Another decision is the similar line, my lord. This is AIR 2025 SC 13001. I'll be relying upon on paragraph 18, 19, 20 and 21. Eighteen, 19, 20 and 21.
Yes, any other point?
And although my lord, the decision of the director is there to take a final call regarding the approval or qualification of the private respondent, my lord. I just want to clarify two things, my lord. while arguing, the other side has raised one point that the private respondent has over-aged minors. But
So in the which paragraph of your affidavit in opposition, you have taken the plea that the director has not yet taken any decision in respect of selection of the private respondent.
para, the very first point, para 5.
Yes.
Then regarding each of the private respondents, I have taken plea in para 8 months. Although the private respondent was overaged, but he has come under the since he is PWD candidates, he got the relaxation of 10 years, It is mentioned in the advertisement itself, Page 124, point number 5. Page 124, Point 5 says maximum age limit is 38 years as of 1/1/2023, with a relaxation of 3 years for OBC and OBC and 5 years for SC ST and 10 years for PWD candidates. There are one notification also regarding selection of candidates for the post of registered professor and the age relaxation says in point number 2. Point number 2. 38 years is as of first day out of a year in which 10 years of PWD candidates election. Another thing, while arguing, the other side showed one website, simply showed. They have linked this fact by way of additional affidavit. Affidavit reply, they have mentioned that the website namely showed, and it was the content of the petitioners that this website is maintained by UGC, and in that website, the department shown against the name of the petitioner is Bengali. That's why the petitioner has obtained her PhD, the Department of Bengali. Now, my lord, kindly see the printout taken from the website, my lord. This first, if my lord see on the first page, my lord, a desired board of Indian thesis. Then right below read more, that is, my lord, when I click the read more, the second page comes about Short Ganga, about the website, my lord. It's about. I'll come to page The third page, my lord. And third page, third para. Sword Ganga so is set up using an open source digital repository software. Got it, Mala? Software called eSpace developed by MIT in partnership with so. The eSpace uses internationally recognized so. Then Mala Sword Ganga provides a platform for research scholars to deposit their PhD thesis and make it available to the entire scholarly community in open access. The repository has the ability to capture, index, store, disseminate, and prevent ETDs, electronic thesis and dissertations submitted by the researchers. That was the last paragraph. Sword Ganga replicates academic structure of each university in terms of departments, like centers, colleges. Each university has to facilitate ease of navigation. This structure facilitates research scholars from universities to deposit their thesis in the respective department, centers, colleges, and supplies. But this is a website where the candidates who have obtained PhD, they submit their thesis and by way of and they themselves incorporate those details regarding the department name, their name, the thesis. Nothing to do with the website does not certify the petitioner or any other candidate having PhD that on which department or which subject they have done their PhD. It is only a repository for access to all. So this having name in this website does not give any right or does not show anything that the PhD obtained by the petitioner is in the concerned subject.
Okay. Any other point?
That's all, madam. My submission is that since the petitioner doesn't have the qualification to participate or to qualify for the post, madam. So the petitioner doesn't have locus to challenge the recommendation or selection of the private respondent. And moreover, madam, the decision of the private respondent is yet to be finalized by the director. That's why, madam, this petition is not maintainable and liable to be settled.
Yes, Mr. Sen, what is your reply?
My lord, so far my learned friend has, my lord, submitted. I'll reply, my lord, on point of law, my lord. My lord, first of all, my friend has submitted that this petition is premature, my lord. So far as, my lord, this point is concerned, my lord, your lordship kindly see, my lord, we have challenged the in order at page 182. But prior to that, my lord, your lordship kindly have a look, my lord. The order passed by this honorable court. 149, my lord. Relevant para, my lord. Paragraph 12. This is, my lord, third round of litigation, my lord. Paragraph. As your lordship got it, my lord. Page 157. The director, may I read, my lord?
Yes.
The Director of Higher Education, Assam, upon considering the contentions made by the petitioner, herein the representation now permitted to be submitted by her, and upon hearing the petitioner, the respondent number 15, my lord, in earlier petition, Here, my lord, respondent number 8 was arrayed as respondent number 15. As well as the college authorities proceed to dispose of the same by issuing a speaking order. It's very important, my lord. Speaking order, my lord, containing the decision as may be arrived by the director, Higher Education Assam, along with the reasons basing on which such decisions should arrive. First of all, speaking order, my lord. My lord, your lordship knows, my lord, there has to be some reason assigned over there. My lord. Now let us see, my lord, whether the impugn order passed by the, my lord, director, Higher Education, my lord, at page 182, my lord, it is put under challenge, my lord, whether it is, my lord. With all respect, my lord, in our respectful submission, my lord, this is not a speaking order, but a cryptic order, my lord. The, my lord, director did not apply his mind, my lord. He has, my lord, mechanically, my lord, said the same line, my lord, on the same line what the selection committee has said. My lord, it is the director, as per the rules, my lord, I'll come to that. It is the director who has to apply his own mind. He is not go by the, my lord, the instructions or, my lord, the recommendations of the selection committee. He has to take, my lord, as my learned friend has already pointed out, my lord, he has to, my lord, take a final call. My lord, by this order, your lordship will find that the director has followed the recommendation. He did not apply his mind. And, my lord, he has not assigned any reason whatsoever as to why, my lord, my candidature has been, my lord, rejected. Now, my lord, from the bare perusal of this impugn letter, my lord, your lordship will see, my lord, only a single stroke, single line, my entire degree, PhD degree has been, my lord, negated. My lord, what they say? Whereas Dr. Panomma was heard, her grievances being her PhD degree was not accepted by the selection committee for the post of Assistant Professor, Department of Bengali, Pandit Dayal Upadhyay Adarsha Mahavidyalaya. So, Election committee has stated in its report, lordship kindly mark, my lord, is not concerned subject. And as per DHE guideline, my lord, DHE guideline did not say anything about this, my lord. I'll come to the DHE guideline, my lord. Your lordship has also seen, my lord, DHE guideline. Nowhere it is said, my lord, that, my lord, DHE guideline, my learned friend also pointed out, my lord, nowhere it is stated that it is as per the DHE guideline, my lord. Now, Dr. Onomma Rai did not have net slate at the time of interview. She could not pass the interview. Now, net slate, my lord, I have obtained, my lord, thereafter. Thereafter, along with representation, my lord, I have submitted the net certificate, my lord. Now, this is subsequent event, my lord. The subsequent event has to be taken into consideration, my lord. This is my second limb of argument, my lord. First of all, my PhD is, my lord, absolutely in the Bengali department, my lord. With all respect, my lord, if your lordship now kindly come the thesis of the petitioner that we have submitted along with the petition, my lord. This order, with all respect, is not a speaking order. Because, my lord, the director has not did not apply his mind. He only says, my lord, that since my lord, the selection committee has come to a conclusion that the PhD degree of the petitioner is not in consent subject, so she cannot be, my lord, allowed for appointment to the post. This is not the order in pursuance to the, my lord, order passed by this honorable court. This is my respectful submission. There is no reason as to why, my lord, the petitioner is not in, my lord, subject concern, that is in Bengali language, my lord.
No,
That is-
Mr. Sen, you
Well-
see, on the date of advertisement, you did not possess the net or slat.
Thereafter, my lord,
Hmm.
and for that, my lord,
But
I have-
no, by completing the net and slat
Correct.
after the date mentioned in the advertisement, can it be said that you have fulfilled the requirement?
correct, my lord, that, my lord, we have relied upon the judgment of the apex court.
Hmm.
But the subsequent event has taken, is required to be taken into consideration. my lord. We have already submitted the, my lord, the judgment.
Hmm.
But my senior Mr. Dor, my lord, argued the case.
Hmm.
We have filed, my lord, set of judgments along with the, my lord. 2010 13 SCC 203. State of Uttar Pradesh versus Bhupendra Nath Tripathi and others. There are 31.
No, no, what is the citation?
Two thousand one SCC.
Six, 762. No, no, on the other day, you have submitted one list. In the list, there is no mention about that judgment. Yes, I do. It's the same, you see, on that day you have furnished one list. That decision is not mentioned in your list. And you have not submitted the judgment, though you have filed the list.
Raj versus.
But you have just a few minutes back, you have cited another decision. No, no, that judgment you have not referred to earlier. And you have not submitted also.
It's in this list, my lord. Uh, The earlier judgment which I have pointed out, my lord, that is, my lord, my lord, election committee cannot undermine the degree, PhD degree, my lord, issued by the university or university.
No, that was earlier not referred to, so, Mr. Sen, you cannot again reopen the argument already completed by you. You have to,
Law, my lord.
no, Mr. Sen, you see, you have to answer you have to reply his
Yes,
argument only.
his queries, my lord.
Hmm.
What he has submitted,
Hmm.
I am answering to that
You
point.
cannot reopen the earlier argument.
I cannot, my lord. But what my learned friend has submitted, my lord,
Hmm.
I have to counter that on the point of law as well as fact. That doesn't mean, my lord, the reopening of the, my lord, the argument. What
No.
he has submitted, today he
You
has
have referred to
submitted.
a judgment which was not earlier referred to.
Earlier, he did not raise this point, my lord. Now today he has raised this point, my lord. Therefore, I have to counter this, my lord, on the point of law. Law made by the Supreme Court, my lord. That is what I am submitting. Now, my lord, so far as this point your lordship has, my lord, pointed out to whether, my lord, the subsequent degree obtained by the petitioner,
Hmm.
subsequent point of, my lord, whether it will be taken into consideration. Honorable Apex Court has held, my lord, in this judgment, 2001 to SCC 6762, my lord,
Hmm.
number 11.
Hmm.
There are 9 of my regarding this plate, my lord.
Hmm.
Reply to this. Well, in our reply, you have stated, my lord. Paragraph number 11, my lord, in our reply. Has your lordship got it, my lord? Paragraph 11,
Yes.
page 199. The statement made in paragraph number 7 of the affidavit in opposition filed by the respondent number 2 in the instant petitions are false and misleading, and as such I deny this. It is mentioned herein that the petitioner in the meantime qualified in the national eligibility test as per the certificate so and so issued by the authority concerned, which is mentioned in the representation so and so submitted by the petitioner before the respondent number so and so for consideration of appointment to the of the petitioner to the said post in pursuance to the judgment and order dated 29/4/2024 passed by this honorable court in the earlier petition number so and so filed by the petitioner. It is mentioned here that the PhD degree is not a mandatory requirement for appointment to the post of assistant professor in colleges as per government dated 14/1/2020. However, the respondent number 2, despite the representation submitted by the petitioner, declared that the petitioner submitted by the petitioner is disobedience of the judgment in order to get so honorable court in the institution. It is mentioned here that all subsequent events, this is important. All subsequent events, including the national eligibility test, is required to be taken into consideration by this honorable court in the instant case in order to complete justice in the case as per law reported in another 2001 have stated 2001 2 SCC 762 Lexus versus paragraph number 11 of the
Where is that judgment now?
Submitted, my lord.
Where?
Right, so- Quota.
Mr. Sen, only the list is submitted, judgments were not submitted. Where?
Submitted.
But the judgment is not submitted. Where?
My lord.
Where?
Well, along with the list, judgments were also produced.
No, you have submitted before whom? Courtmaster is saying that no, only the list was submitted.
And list the judgment.
The judgment, thereafter, lordship said, could make a list according to the. And to.
No, he has been saying that only the list was furnished,
Before.
not the judgment.
I'll. I'm told that you furnish my best. If it is not there, sir.
No, not there means it is not submitted.
Would submit it faster than the text and later on would submit extra only.
No, as per his version, you have only submitted the list. Then he told you that you submit the judgments also, but you have not submitted the judgments.
Submitted the judgment. But
Later on, after the case.
Be fine to summarize.
Lord, if necessary, will.
Okay, you complete your reply and thereafter you furnish the judgments.
This Munilal.
Okay.
In the case subsequent event or fact having bearing on the issues or relief in the suit or any party may seek to bring on record. All laws and procedures including the court are all in aid of to confer justice to all who wrongs itself. So interpret the law not in violation of justice, but it is free. Thus bringing on record subsequent event which the relevant to permitted to brought on record to render justice to the party. Finding. Also, when a subsequent event. 1975, 1 SCC 770.
19.
75. 1 SCC.
Okay.
20 events. Another contention is that the respondents whether by finding that as happened in opposition letters not deny the contents made by the repetition. They did not deny the contents of the repetition. Therefore, the Supreme Court has said in the judgment with the 1993 SCC 157. I'm sorry. What? AIR 1993, Supreme Court, page 29259. Nasib Banu versus State of Uttar Pradesh. There are 9 different divisions. There are reports in reply which show that on behalf of the respondent number 1 to 5 it was not disputed that 40% of the post could be picked up by the promotion may not be picked up by and the entire of the promotion to the appellant was not justified on the field notion was not qualified. And the event will also be put down below. The High Court has gone into it and has raised the appellate has raised the subject of the term of appointment of the respondent number 2 by the their reply amendment made that the post the state government does not take control. The High Court should have proceeded on the requirements. Therefore, the facts not admitted or not denied as presumed to be admitted and on the basis of that, the Supreme Court says that the High Court should have been proceeded on the basis of the amendment. Millard, filed by James, it did not go at and so far as matter needs to all respect they have answered in paragraph number 4, page 196 of the Lordship crisis.
Paragraph number?
Paragraph number of our slide.
Yes.
Statement made in paragraph number 5 of that and 5 of the respondents. The false it is mentioned here in that honorable court does not contain an order replacement from past. Pursuant was pleased to direct the to take respondent number 2. According to honorable court has passed left hand order, sir. Saying that it finance. But the by issue of the order, may not filed by the sector. It is by which order, so this is not in accordance with the order passed by. 20.
Mr. Sen, the question is, can this court in writ petition, this present writ petition, can consider whether the earlier direction was complied with or not?
Order.
Mhm.
But dictate to consider the representation filed by the petitioner thereafter filed the representation. But that representation does not has to be disposed of by the spirit order. Pursuant to the order passed by the Supreme Court. But by the given order, the director has passed a strict order, the one line order. That the petitioner is the degree of not in concern subject. Now, how it is not in concern subject, that reason is not the same. Therefore, my lord, the director did not apply his mind. That is my responsibility. The order was, my lord, take a final decision and to pass it to order. Meaning there was deciding reason, my lord, as to why my degree is not in concern subject, Lord, it's subject. Bengali department. However, to that effect, my lord, I rely upon the judgment of the apex court, my lord, who says, my lord, that a selection committee, my lord, by saying that I am not called, petitioner is not of concern subject in Bengali department is otherwise, my lord, undermining the authority of the university. Or university grant commission, sir, this is not permitted under. Ten.
2010-13 SCC.
Paragraph 31 is the relevant paragraph. I got the government body or the selection committee cannot question. Whether degree obtained by the petition. But it cannot undermine the authority of the university.
No, they even cannot examine whether it is on the subject or not.
Concerned with the university who has issued the degree, they did not pay us. That's why, Lord, we say, Lord, that the recommendation of the respondent number 8, my lord. Although he has got lower marks than me, my lord, I got the higher mark. As for the comparative statement, my lord, I have got 45 marks, my lord, she has got 37 marks. But even then she has been recommended. But I got academic area. She is not, she is third division. I am all along first division. But my case has been ignored. I have submitted all the documents, all the certificates, which goes to show the academic report of the petitioner is uniformly put, which is one of the criteria of the guideline.
Maybe, but you did not possess net or slate on the date of advertisement.
That was subsequent. That is why the representation I have submitted. The slate degree, net degree. That has been overlooked. For that, that's why, my lord, I have quoted the judgment, my lord. Subsequent. Later.
Okay, any other point?
This, my lord, 2013, still, my lord, say that they consulted the University Grant Commission whether this, my lord, degree that has been given by Mahatma Gandhi University is whether it concerns subject or not.
Hmm.
But simply saying on the basis of the title, my lord, they cannot come to a conclusion that it's not a subject. For a moment, my lord. This is that we have some.
No, already you have shown it and the respondent.
Chapter number 4, my lord, chapter number 2 and chapter number 4 of my. It says, my lord, how the Bengali language.
Hmm.
Thereafter, my lord, how the, what is the Bengali culture?
Hmm.
What is the language of the Bodak Valley? But how the Bengali language has been evolved? Then culture, then food.
Hmm.
So, my lord, culture, the culture of the, my lord, Bodak Valley or Bengali. My lord, is a
Okay.
part of the syllabus of MA. My lord, any part of the syllabus of MA, my lord, I can show that one can, my lord, make thesis or PhD on that particular subject in MA. And I had a MA degree on any subject on Bengali. Because you will find it from my MA certificate. And the MA certificate obtained by the respondent number 8 of campus is not by this as per the judgment of the court. Court.
Hmm.
Therefore, by saying whether we are merely on the basis of the title of this, whether this thesis,
Hmm.
they should not have come to a conclusion that this is not a because other aspect of the matter, chapter.
Oh, Mr. Sen, you see, the selection committee comprises of some of the experts nominated by the university, right? They have taken a decision. Can this court substitute its view, its opinion?
They are also not an expert. Expert is the university grant commission.
Hmm.
They should have consulted.
No. The in the order. No, Mr. Sen, you see, in the order constituting the selection committee, the person has been designated as subject expert. Have you seen the order? Then.
But that is also say, even then they are expert.
Hmm.
In the committee, my lord, even then they are expert. Even then they are HOD of the department. But even then, they cannot say that the degree is not accepted. Because this is the aspect, my lord.
No. If that would have been the criteria, then there ought to have been the members of the UGC, expert of the UGC, in the selection committee.
Persons who are with the persons in the selection committee. There is a guideline.
Hmm.
Yes. There are persons who are professors in Bengali department. Pointed out this.
Hmm.
Persons are there. Who are on the subject Bengali department.
Hmm.
But can they? That is my question. Can they undermine the certificate or degree issued by the university authority?
No, where they have undermined.
They are under. They say rejecting my.
And how they have undermined.
Because they say my Bengali department.
Hmm.
Where Shodhgonga says department. I have annexed the
So
Shodhgonga in the.
what is the status of Sudgonga?
Shodhgonga, my lord,
Hmm.
It is maintained by the university grant function.
Hmm.
So university grant function.
Whether it has any, whether it has any legal entity,
Yes,
how?
because university grant constitute. Yeah.
Hmm.
Or digital, digital library,
Hmm.
to appreciate the thesis of
Hmm.
the person who are willing to upload their thesis.
Where it is stated that South Ganga is established by UGC?
Norton concern subject. Paragraph 9.
In which paragraph of your affidavit you have mentioned it?
My lord, paragraph number 9 at page 197. That the statement made in paragraph number 6 of the affidavit in opposition filed by the respondent number 2 in the instant writ petition are false and misleading as such deny this. It is a false statement that although the concerned department of the petitioner is Bengali, but she pursued her PhD from Mahatma Gandhi University, Meghalaya, in the Department of Culture Studies, Center for Interdisciplinary Studies, and hence the selection committee, after examination of every aspect of the candidate, opined that PhD of the petitioner is not concerned subject mentioned as per DHE guideline, and as such the petitioner in the case is not eligible to be considered. It is mentioned here in that the respondent number 2 has made such statement in the affidavit in opposition filed by her in the instant case Melafadi without taking consideration of the website of University Grant Commission, namely Shodh, which clearly shows that the petitioner pursued her PhD degree with title of her thesis, namely Socio-Culture Study on Borakbili of Assam from the Mahatma Gandhi University in the Department of Bengali. This is very important. And without consulting, this is very important, without consulting the Mahatma Gandhi University, Meghalaya, or University Grant Commission, which undermines the authority of the university concerned, as per reported in 2010, 13 SCC 203, State of Uttar Pradesh versus Bhupendra Nath Tripathi. A copy of the extract of the website of the so-and-so University Grant Commission, namely Shodh, is annexed as Annexure 1 of affidavit. But Annexure 1 at page 205. And my lord, Honorable Supreme Court has said, my lord, before come to a conclusion of such finding, my lord, they should have consulted with the University Grant Commission.
Hmm. Okay, any other point?
Wait a judgment. My lord, off-campus judgment we have already submitted. I'll submit, my lord, it is not submitted. I'll submit of the WPC number 2983 of 2017. Purnendu Shekhar De versus State of Assam. This is judgment of coordinate bench, my lord, of this honorable court. It says that, my lord, the off-campus degree, whether it is, my lord, bachelor or master, is not, it is, my lord, not valid. Therefore, the PhD of the respondent number 8 that is also not valid. That is our respective submission. Since her MA degree is of off-campus, my lord, her PhD is cannot be said to be, my lord, valid.
Okay.
And 1 point, my lord, 1999 6 SCC 49, my lord. Says, my lord, expiry of the panel advertisement, although my learned friend has not pointed out that, my lord. But law says, my lord, Supreme Court said, my lord, the continuation of the proceeding, my lord, will not expire the term of the period as mentioned in the advertisement. So that's all, my lord. That is our respective submission. My lord. I'll provide all the judgment, my lord, along with the list.
Now, I also want judgment that is the last set of submission of requirement at the last.
Okay.
I'll provide you the purpose.
Heard Mr. Sen, learned counsel for the petitioner. Mr. S. Das, learned standing counsel for the respondent in higher education department. Argument concluded, judgment reserved.
Judgment will have to be, sorry. Well, it's CAB, my lord. CAB.
Yes.
Yes. I am deeply obliged, my lord.
May please, Your Honor.
Yes.
My lord, the matter pertains to a selection process. There was an advertisement for the post of assistant professor of Sanskrit in Nalbari College. And, this was, the date of the advertisement is 4/7/2015. Now, when the selection process was going on, the respondent number 6 herein filed a writ petition saying that the OM that was applied was in fact not applicable. And the judgment your lordship will find at page 48. The petitioner is the respondent number 6 herein. Your lordship kindly turns to page 49. What was the challenge is reflected at paragraph 4. The petitioner accordingly offered her candidature against the aforesaid advertisement, and she was issued a call letter bearing number so-and-so, dated so-and-so, requiring her to appear in an interview, which was scheduled in held on 4/10/2015. The petitioner accordingly appeared in the interview and could learn that the selection committee was also awarding certain marks for the oral interview that the candidates were subjected. The petitioner was aggrieved in as much as the office memorandum dated 25/6/2012, which held the field when the advertisement was issued, did not provide for holding any interview. According to the petitioner, the procedure adopted by the college authorities in holding the interview was dehorsed the procedure prescribed by the office memorandum dated 25/6/2012. In the aforesaid premises, this petition has been preferred for setting aside the selection that was held on 4/10/2015, with the further direction to hold a fresh selection strictly as per the procedure laid down in the office memorandum dated 25/6/2012. This was allowed, man. If your lordship will kindly turn to page 51. At paragraph 10. In the view of this court, the ratio laid down by the Supreme Court in Madan Mohan Sharma would be squarely applicable in the facts of this case. Also, inasmuch as on the date on which the advertisement was issued on 4/7/2015, the office memorandum dated 25/6/2012 was in force, whereas on the date when the interview was held on 4/10/2015, the subsequent office memorandum dated 14/8/2015 had in the meantime come into force. Accordingly, this court is of the considered view that the selection process pursuant to the advertisement dated 4/7/2015 would be covered by the procedure prescribed in the office memorandum dated 25/6/2012 and not the subsequent office memorandum dated 14/8/2015. As the office memorandum of 25/6/2012 did not provide for holding any interview, therefore, the act of the respondent authorities in holding an interview on 14/10/2015 and awarding 20 marks for the purpose would be without jurisdiction and divorce the provision of the office memorandum dated so and so. And accordingly, to that extent, the petition was allowed. 53, and a specific direction was given that the OM of 2012 be applied. Now, this OM of 25/6/2012, your lordship will find at page 54. It's a very long OM prescribing the procedure. We are concerned with page 56.
Yes.
Your lordship will find towards the bottom of the chart, serial number 2, teaching experience, 5 marks. Teaching experience, 1 mark for each completed year. Your lordship will kindly note this one. 1 mark for each completed year of service in an affiliated government last degree college, subject to maximum 5 marks. So, for each completed year of experience, the candidates will be entitled to 1 mark. Now, in support of this, the petitioner submitted a certificate which your lordship will find at page 27. This is the typed copy. The original is at the next page, page 27. Very interesting certificate was submitted by her. This is to certify that MS Chandana Deka, so-and-so, has served as a teacher in Sanskrit in an ad hoc capacity during the session 2009-10 for 1 year. He was a sincere, etc. etc. Now, this certificate raised serious doubts. So, what she did was she produced another certificate, which your lordship will find at page, second certificate, 26. I'm sorry, my lord. I'm sorry. The first one is at page 26. The certificate that was originally submitted is at page 26. This is to certify that Ms. Chandana Deka, etc., served as an ad hoc lecturer. Your lordship will kindly note this. Ad hoc lecturer in the Department of Sanskrit in so-and-so during 2009-10, and she has been serving as part-time lecturer for the session so-and-so and so-and-so. Both are purely temporary and terminable basis. So, this is what is the exact period, etc., is not mentioned. So, when doubts were raised regarding this, she produced the page 27 certificate. This one mentions 1 year. Earlier one had not mentioned 1 year. If your lordship will kindly note the date, my lord. 10/2/2015. This apparently, this fresh certificate was apparently submitted pursuant to this application at page 33. Your lordship has noted the date at page 27. It is 10 to 2015. Now, the certificate, the application. This is the application that the respondent number 6 submitted to the principal, the college. Sir, with due respect, I inform you that I served as an ad hoc lecturer in the Department of Sanskrit in your college during 2009-10 and have been serving as part-time lecturer for the session 2010-11 and 11-12. Both are purely temporary and terminable basis. Now, I am in need of a certificate of an ad hoc lecturer during 2009-2010 mentioning 1 year service, for which act of kindness I shall be grateful to you. She is in need of a certificate, therefore a certificate is required to be given. But there is no mention even in the application that she actually served for 1 year service. And based on this page 27 certificate is submitted. 1 year. Now, the selection process has been completed, and the difference between me and the respondent number 6, the petitioner is also a candidate. There is a difference of some point something. Well, now our contention is, if your lordship will kindly come to page 30. And one thing I must point out to your lordship, before I go to page 30, at page 33, your lordship will find a very interesting thing. She submits the application without any date, but 17th March, and it was received on 17th March, but the certificate at page 27, your lordship will find that even before she submits the application, this 10 to 2015, more than a month before the application, the certificate is already issued. There is some manipulation there also. Either as it may, if your lordship will kindly come to page 30. The period that is mentioned in the certificate is 2009-10. At that time, this OM was in force. 12th of October 2004. Your lordship will kindly see the subject. There is a complete ban, prohibition of engagement of teaching and non-teaching staff in deficit grants in a college without sanction posts. In continuation of this department so-and-so dated 17/7/2004, the following procedures formalities are prescribed for banning the appointments of teaching, non-teaching staff against non-existent posts in deficit grants in aid colleges. Henceforth, no college under the deficit grants in aid system shall engage any person for a teaching or non-teaching work where no sanction posts exist for the purpose of filling up of vacant sanction posts. Existing government instruction guidelines will be responsible for any violation of the so-and-so above sanction conditions. All members of the governing body or college, including the principal secretary of the college, will be responsible for any violation of above conditions. The member secretaries of the respective colleges shall invariably submit reports of compliance to the above conditions twice in a year. Second report as on 1st April of the year and second report as on 1st October of the year as a precondition for release of fund to such college by the state government. So, during the period for which she produces the certificate, 2009-10, there was an absolute ban of making appointments. If posts are not in existence. Now, the fact that the posts are not in existence are there was also an RTI application, and the response to that is at page 31. So 31 is the application, and if your lordship will kindly come to page 32. Serial number 3. We asked the college, and this is the reply given. Serial number 3. Copy of the appointment letter of the incumbent could not be traced. Then the college could not trace the office copy of joining report. The college could not trace the office copy of termination letter. Then at the bottom, what is mentioned is even more interesting. The undersigned issued the experience certificate on the basis of the one issued by my predecessor after verifying the acquaintance registered during 2009. So this principal who has issued the certificate, he is not even aware. Only because an RTI certificate was issued, he simply adds that 1 year word in the certificate and issue the press cert. There is no record whatsoever of our appointment, our termination, our joining, nothing. In spite of that, and now finally they have admitted, if your lordship will, this MNC college has filed an affidavit the fact that there were no sanction posts at that relevant point of time. If your lordship goes to the running page 137, that is an affidavit filed by affidavit in reply. There is an affidavit in reply filed to the affidavit in opposition filed by the respondent number 7 and 8. At 137 it starts.
Yes.
If your lordship will turn to page 144, internal page 74.
Yes.
This is again in response to some query raised regarding the certificate. And this is the response. I have the honor to state that there are no, even as on date of, this is in 2022, even till 2022, there are no sanction posts. I have the honor to state that there are no sanction posts of assistant professor in the Department of Sanskrit in MNC Balika Mahavidyalaya. So if there are no sanction posts in terms of the 2004 OM, there is a ban. No appointment could have been made. So therefore, the 1 mark our contention is that the 1 mark for the period 2009-2010 under no circumstances could have been awarded to the respondent number 6. Mark for difference and if this mark is not awarded, I will be selected at serial number 1 in the merit list, not her. And I will be entitled for appointment. That is why that is the challenge before your lordship. Very short point otherwise. Goswami judgment to Kotasan. Huh?
25.
I agree. When we raise this point by filing this repetition, they have come up with a previous judgment of this honorable court And that judgment, your lordship will find there was an IA file, my lord, 3505 of 2022. That judgment is annexed to that. This is the judgment that they place reliance on to say IA 505. This same certificate was put to question by another candidate in respect of selection and appointment in another college. And if your lordship will come to page 25 of the IA.
Yes.
This was by a completely different person, some Chandan Hazarika. WPC number 3245, 2015. It is in connection with selection in ADP College, Nagaon. And in fact, my instruction is that the respondent number 6 is continuing to serve there in ADP College, Nagaon. Now the challenge is page 27, paragraph 6. They say that this certificate was already a matter of dispute in another litigation. And validity of the same has been upheld. So how can I now question? That is the contention. So I'd like to show before your lordship how this judgment is not even applicable to. The dispute herein lies in respect of grant of 1 mark out of 4 marks. Principal of Mohendranaran Chaudhary Balika Mahavidyalaya, Nalbari had issued a certificate dated 10/2/2015. It is the same certificate, certifying that the respondent number 6 had served for 1 year as an ad hoc teacher in Sanskrit in
Which
college
paragraph you were reading?
Paragraph 6, my lord, page 27.
Yes. Okay.
Paragraph 6 at page 27. The dispute herein lies in respect of grant of 1 mark out of 4 marks. Principal of Mohendranaran Chaudhary Balika Mahavidyalaya, Nalbari had issued a certificate dated 10/2/2015, certifying that the respondent number 6 had served for 1 year as ad hoc teacher in Sanskrit in 2009-10. This certificate was doubted, and the contention advanced is that the respondent number 6 did not render service for 1 year in the aforesaid Mohendranaran Chaudhary Balika so and so. If the aforesaid certificate is disbelieved, the marks obtained by the 6 come down to so and so. We are not concerned. Now, para 29 is the issue that has been framed. The page 29, para 14. The question that has emerged for consideration is whether the respondent number 6 was sought to be given undue benefit on account of experience by respondent number 7, demonstrated by the certificate issued by him in favor of the respondent number 6. And now, it is seen that the respondent number 6 was appointed not on the basis of the resolution adopted by the governing body of the college, but by the principal of the college on the strength of a resolution authorizing the principal to appoint a lecturer on need basis. If the college authorities are unable to produce the appointment order issued in favor of the respondent number 6 or the joining report, the respondent number 6 cannot be penalized. That is the contention. And ultimately, the court held that she had worked. But the question here is different. You also will find that in this particular case, this OM of 2004, it does not matter whether she has worked or not. That time, there was a ban. There is a legal fiction gets created. There was a prohibition for making an appointment if a sanctioned post does not exist. So she might have physically worked. But the question is, on account of this, that even if she has physically rendered service, the appointment itself will be invalid because it will be an illegal appointment in violation of the OM. So if the appointment is illegal, can that 1 mark be given? And this question perhaps it was overlooked by the petitioner in this case. This OM of 12/10/2004 was never brought to the notice of this honorable court. And this particular issue, this particular question of law never arose for consideration. And since I was not a party to the proceedings, I obviously this judgment would not apply to me. Here, the adjudication is on a completely different question of law. To formulate the issue, my lord, the issue would be, even assuming
Yes.
the question that would arise here is, even if she has rendered the service in view of the ban, that appointment would be illegal. And for an illegally rendered service, whether that 1 mark would be, she would be entitled to that 1 mark. That would be the issue that would arise before your lordship. And the difference in marks, it indicated there is an affidavit in opposition filed by the respondents number 3, 4, and 5 in the main writ petition. This is the selection committee and the director of education, higher education. It is an affidavit in opposition by the respondents number 3, 4, and 5.
Yes.
If your lordship kindly turns to page 7 of that affidavit, it is a very long paragraph. So I'm not, it is a part of paragraph 6, which starts at page 5. Very long paragraph. Page 7 at the very top, the difference in marks is reflected. So if that 1 mark is, if your lordship holds that the respondent number 6 is not entitled to that 1 mark, I will steal a march over her. At the very top, your lordship will find. On 25/4/22, the selection committee thus concluded the selection procedure after pinning down their allotted marks to all the candidates. Pursuant to which the consolidated statement of marks allotted to all the candidates for the post of assistant professor in the Department of Sanskrit, Nalbari College, Nalbari, was prepared, in which the respondent number 6 secured highest marks, 69.37, and the petitioner secured 68.65. So if your lordship holds that the respondent number 6 is not entitled to that 1 mark, I come to the top of the merit. That is the prejudice that has been caused to me. Now, on this judgment, my lord, the only contention is that there is already a judgment where the doubts raised regarding her service during the period 2009-2010 has already been answered. So therefore, it will cover this case also. And to that, as I have already pointed out, my answer to that is this OM of 2004, 12/10/2004 was never an issue before this honorable court in that particular case. That was never brought to the notice of this honorable court. So therefore, naturally, it is a judgment sub silentio on that. Not only sub silentio, it is a judgment per inquiry. And on that, my lord, how a judgment is to be understood on that issue, I would like to place a few judgments. Perhaps we can continue at 2. Just 2-3 judgments I'll place. At 2 o'clock.
No. For another 15 minutes, I will continue.
Yeah, perfectly. 2003-7 STC. 2003 volumes 7 SCC 197.
2000?
2003, volume 7 SC, 197. Relevant paragraph is paragraph 23. Man.
Yes.
So far as Nagesha case relied upon by the claimant is concerned, it is only to be noted that the decision does not indicate the basis for fixing of the quantum as a lump sum was fixed by the court. The decision ordinarily is a decision on the case before the court, while the principle underlying the decision would be binding as a precedent in a case which comes up for decision subsequently. Therefore, while applying the decision to a later case, the court dealing with it should carefully try to ascertain the principle laid down by the previous decision. A decision often takes its color from the question involved in the case in which it is rendered. The scope and authority of a precedent should never be expanded unnecessarily beyond the needs of a given situation. The only thing binding as an authority upon a subsequent judge is the principle upon which the case was decided. Statements which are not part of the ratio decidendi are distinguished as obiter dicta and are not authoritative. The task of finding the principle is fraught with difficulty, as without an investigation into the facts, it cannot be assumed whether a similar direction must or ought to be made as a measure of social justice. Precedents sub silentio and without argument are of no moment. Mere casual expressions carry no weight at all, nor every passing expression of a judge, however eminent, can be treated as an ex cathedra statement having the weight of authority. Therefore, this OM of 2004 never having been placed or discussed, that judgment will be of no avail. My lord. The next judgment, my lord, I am relying on is 2006, volume 6 SC, 366. And the relevant paragraph is paragraph 13.
Yes.
The High Court unfortunately did not discuss the factual aspects, and by merely placing reliance on an earlier decision of the court held that a reinstatement was mandated. Reliance on the decision without looking into the factual background of a case before it is clearly impermissible. A decision is a precedent on its own facts. Each case presents its own features. It is not everything said by a judge while giving judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided, and for this reason, it is important to analyze the decision and isolate from it the ratio decidendi. According to the well-settled theory of precedents, every decision contains three basic postulates: findings of material facts, direct and inferential. An inferential finding of fact is the inference which the judge draws from the direct or perceptible facts. Number two, statements of the principles of law applicable to the legal problems disclosed by the facts. Number three, judgment based on the combined effect of the above. A decision is an authority for what it actually decides. What is of the essence in a decision is its ratio, and not every observation found therein, nor what logically flows from the various observations made in the judgment. The enunciation of the reason or principle on which a question before a court has been decided is alone binding as a precedent. A case is a precedent and binding for what it explicitly decides and no more. The words used by judges in their judgments are not to be read as if they are words in an act of parliament. In so-and-so versus so-and-so, observe that every judgment must be read as applicable to the particular facts proved or assumed to be proved. Since the generality of the expressions which are found there are not intended to be exposition of the whole law, but governed and qualified by the particular facts of the case in which such expressions are found, and a case is only an authority for what it actually decides. In similar lines, my lord, the next judgment,
On the same point. On the same point.
slightly different, my lord. Here, the Supreme Court goes on to say that even if there is a little difference of facts, it makes a huge difference. The precedential value will erode. It is 2003, volume 2, SCC 111. Just one very short portion I will. It's a very, very short paragraph that I am like. 2003, 2 SCC 111. And the relevant paragraph is paragraph 59. Paragraph 59 at page 130.
Yes.
A decision, as is well known, is an authority for which it is decided and not what can logically be deduced therefrom. It is also well settled that a little difference in facts or additional facts may make a lot of difference in the precedential value of a decision. So in our case, my lord, there is not a little difference, there is a massive difference. It brings in a whole new dimension because of the OM of 2000. And the last judgment on the issue, here the Supreme Court goes a little further. And Supreme Court says, let me read out the paragraph. It is 2002, volume 3, SCC 496. And the relevant paragraph is paragraph 19. At page 50. Courts should not place reliance on decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. Observations of courts are not to be read as Euclid's theorems, nor as provisions of the statute. These observations must be read in the context in which they appear. Judgments of courts are not to be construed as statutes. To interpret words, phrases, and provisions of a statute, it may become necessary for judges to embark upon lengthy discussions. But the discussion is meant to explain and not to define. Judges interpret statutes, they do not interpret judgments. They interpret words of statutes, their words are, etc. The whole context in which the earlier judgment was rendered was different. There, the only conclusion that was arrived at by this honorable court was that she had physically rendered service. That is not the question before this honorable court at this in this case. The issue before this honorable court in this particular case is if that appointment is illegal, whether service rendered illegally service that has been rendered illegally, against that 1 mark would have been granted or not. That is the question before this. That is the short issue before you. Subject to what respondents say. And in fact, my lord, one thing I must point out. On the last occasion when the matter was heard, the state came up with a very interesting argument that the final approval has not been granted by the director. Therefore, this writ petition is premature. If your lordship sees the previous judgment, where the respondent number 6 was the petitioner, she had come immediately before the interview, immediately after the interview. There, no decision was even taken. Your lordship comes to the judgment at page page 48 of the writ petition. Paragraph 4 will reveal that immediately, as soon as the interview was held, she raised a grievance.
Page number?
I have placed the judgment now, page 48. So
Yes.
paragraph 4 will reveal that the respondent number 6 in connection with the same selection process approached this honorable court questioning the interview itself. So selection process was not even completed. In this case, the marks awarded have been disclosed in an affidavit. So therefore, the selection has been completed in this case. So therefore, that issue, even if raised, will not hold water. Otherwise, subject to what they say. And in fact, this matter was heard at some length on an earlier occasion, and we had prepared a short written argument. It was official for it.
Yes, yes.
I think it is already there in the record. If not, Manoj, we can supply. Ask it. এখন নয়, লেগে দিয়ে। আচ্ছা।
Selection committee available experience in the teaching, MCQ same director same selection committee.
Okay, your part is complete.
My part is.
Okay. So we'll start at 2 o'clock.
For 9 and 4 crore.
Pardon?
9. And focus on crore.
So 9th one up. 11th crore.
Not sure for take it up before.
Yes.
While they are continuing matter, I'll come back.
Okay.
One and two.
1 and 2.
Admitted argument, my lord. My only argument is that that this is kind of premature because the argument is to take a final call on regarding approvable or not approvable of the finish of the customer as well. And in that regard, I would like to take the decision of the coordinate bench. Within the parameters.
Okay.
And 4 months for London Stadium Council has pointed out that in RTM Stadium also although the cyber respondent has challenged it did not take
Here you have relied upon paragraph number 6. 4-6.
the first piece I have.
Okay.
And in the petition that is, for the hearing, my lord. Challenge the signature process, my lord. There is no, private respondent was not there. And if the signature process was challenged on the basis of, taking marks or applying a different, office memorandum, that's why that ground was not, taken or that this ground was not, applicable in that case, my lord, regarding premature. Because they are the selection process was under challenge. That is the selection of the determination of the elected candidate is under challenge. That's why, and we have to take it all on that. That's why, one of the case is premature because director can either reject or grant approval.
Okay. Earlier, you have filed a written argument.
Would have known, my lord.
Okay.
My lord. In fact, we have not filed 76.
Okay. Yes, Mr. Solma for respondent number 7 and 8. Who are 7 and 8?
My lord, the 7 and 8 are the experience issue got this of the prior topics. When the petitioner, when the respondent number 6 worked as an ad hoc teacher, my lord. And that's me, my lord. That one.
Principal.
Principal, my lord. President of the governing body is respondent number 7. And
Okay.
number 8 is the principal, my lord.
Okay.
My lord, here also, respondent number 7 and 8, my lord, they have a limited ground. But there's one issue, my lord, I'd like to point out. If a lord can kindly come to put the OA, my lord, at page 29 of the regulation, my lord. Page 29 of the regulation. Page 30, my lord, is the type copy, my lord. Office memorandum, my lord, that is dated 12th of October 2004. Subject. Prohibition of engagement of teaching and non-teaching staff in deficit enhancing aid audits without any sanction. In continuation of this department's number so and so dated 17/7/2004. The following procedures / formalities are prescribed for planning the appointments of teaching / non-teaching staff against non-existent posts in deficit enhancing aid colleges. Number 2. Henceforth, no college under the deficit enhancing aid system shall engage any person for the teaching or non-teaching work where no sanctioned post exists for the purpose of filling up of vacant sanctioned posts existing in government's instruction guideline will be responsible for any violation of the above sanctions conditions. All members of the governing body of the college, including the principal, secretary of the college, will be responsible for any violation of the above mentioned conditions. And number 4, the member secretaries of the respective colleges shall invariably submit report of compliance of the above conditions twice a year, and the second report cannot switch. My lord, this office memorandum, it prohibits the engagement of teaching or non-teaching staff, non-sanctioned posts, my lord. That part of it is not disputed, my lord. That is my senior for the petition have pointed out. My lord, we can come again to point number 3. All members of the governing body of the college, including the principal secretary of the college, responsible for any violation of the above mentioned condition. Now, in this relation, my lord, we are concerned with the issue of grant of marks for the experience of the teacher with this who has rendered service, my lord. Now, the condition, my lord, the facts are not disputed. That there will no sanction posts where respondent number 6 served in respondent number 7 college. There is also no dispute to the fact that the OA was operative at that point in time. What your lordship we may like to
explored, my lord, was that there was a prohibition for engagement. But what happened is that engagement was violated by the college. Thus, the experience come down. Now, my lord, my CA for the petitioner has referred to the earlier round litigation where the petitioner was not made a party. If I may kindly bring the lordship's attention to that part of it. My lord, that is for the KI who filed on respondent on behalf of respondent 7 and 8, my lord.
I.
No, the
Okay.
the individual page numbers of the document. Page 22.
Page?
Page 22. So, respondent number 7, it still is respondent number 8 in this current detail.
Reply. Everything is right. 7 and 8.
7 and 8. That is not 23. 9.
You are referring to page number 74, internal page.
In fact, none of our pages, my lord, have been I think connection of E8.
It is the certificate?
My lord, this was filed by Kirindra Kumar Khattam.
Mm-hmm. What else?
Yeah, based on the next question.
Yes.
My lord, number 40 of the judgment, my lord. Number 40 of the
Yes.
Respondent number 7 demonstrated by the certificate issued by him in favor of the respondent number 6. My lord, this is the same question before your lordship today. That whether the experience of the services rendered by the respondent number 6 in a non-sanctioned post would be applicable for consideration in a subsequent selection process. Now, my lord, that issue has come to a finality, notwithstanding the presence and the existence of the ON dated 2004. My submission, my lord, subject to lordship's final observation, is that the ON 2004 talks about the entry of individuals serving in non-sanctioned posts. The penalty which is enshrined in that ON it does not affect the validity of the service experience given or rendered by respondent number 6. My lord, in the similar instance, my lord, in a matter pertaining to prosecution of PA without government sanction, your lordship in a detailed judgment, my lord, had held that the experience to which a PA candidate had acquired the degree, notwithstanding whether the person had taken permission from the college or not, would not disentitle her for the post or the benefits that will accrue pursuant to holding of a PA. Your lordship,
No, all right, that's all
Yes,
right,
my lord.
all right.
My submission here, my lord, is that it is not disputed that the petitioner, the respondent number 6, had rendered sufficient experience, my lord, sufficient service with the respondent number 7, which has been documented, which has been agreed to and admitted by the petitioner also, my lord.
No,
Or
no,
three subsequent
documented
years.
means, you have failed to produce, the appointment letter.
My lord, subject to correction, my lord, the aspect of my appointment and my services has already been crystallized by this honorable. Now, the only aspect of which, subject to what is also my finally decided, that the only aspect of which that entire aspect can be revisited by this honorable board, that is humbly submitted, is on the existence of that OM of 2004. Because, my lord, neither this order, which is the deferred, my lord, was appealed. The state government did not appeal the order, my lord. That aspect of the appointment letter of the petitioner has lost its credibility because of the attendance roll where my name pictures for 3 years. It has been observed by the honorable court that my name appears in the acquittance roll of the college for 3 years. That has been produced before the honorable court. The records have been produced before the honorable court on the earlier occasion. Now your lordship will see whether the OM of 2004, which is a direction for the colleges, will be barred the respondent number 6, who has admittedly rendered her services in the college for 3 years. In answer action both, my lord, that is not disputed, my lord. Now you also will see whether the experience which has been garnered by the respondent.
No, no, who had admitted it?
We have not admitted, my lord, we have I would have not said it's denied the experience of the mother. Can I only get some big on the earlier occasion when this honorable court had gone into the issue of yes, ma'am. It is seen that the respondent of the 6, the current respondent was appointed not on the basis of the resolution adopted by the governing body of the college, but by the principal of the college on the strength of a resolution authorizing the principal to appoint the lecturer on a need-based basis. If the college authority are unable to execute the appointment order issued in favor of the respondent number 6 or the joining report, the respondent number 6 cannot be penalized. The question is whether there is any acceptable record which persuades the court to take a view. Respondent number 6 has served for 1 year in the college during the resident period. An acquittance rule, my lord, we need the court to come to such a conclusion. If such acquittance rule generates confidence in the mind of the court that it is a genuine record. I've gone through the acquittance rule. It is a bound register in respect to the period starting from the year 2000 to 2020, showing disbursement of salary on month-to-month basis. The acquittance rule, as produced by the respondent number 7, is the whole book and appears to be a genuine document. The name of the respondent number 6 is not always the last name in the list of staff, which should have been the case if the name of respondent number 6 was sought to be legally independent. The acquittance rule that legally. The acquittance rule had chronologically reflected the salary to the government staff and the respondent number 6 had drawn salary for the first time on 10 September 2009. Her name appears from period number 4 below her name made for August. It is indicated as salary paid to her is so and so. In the subsequent months, the respondent number 6 was paid so and so. It's difficult to say on what basis an amount of rupees so and so was paid for 4 months. Now, my lord, we granted on to paragraph number 90. It appears the statement was made in the affidavit of the respondent number 7 that the respondent number 6 had worked from May 2009. We are taking the same stand, my lord, in the affidavit, my lord. On the face of the original record is produced, it is to be taken that such statement was made erroneously. This so and so is right saying that the respondent number 7 of the trial taken in the month of August. They could not have made any appointment in the month of May. But that may not be sufficient to dislodge the claim of the respondent number 6 that she had served in the college for 1 year. It is only indicated that report number 6 had for the first time drawn salary in the month of September. Even if a service record for the month of August 2009, she has completed more than 1 year of service and she continued to serve till month of September 2010. Therefore, successor dated 10/2015 issued by the principal is document based on a policy which can be acted upon for award of marks towards. Therefore, the grant of 1 mark on the basis of the aforesaid certificate to be for the response number 6 cannot be held illegal and arbitrary. This was the opinion of the court, my lord, that even in the absence of the appointment order,
Okay, at that point of time, the OM of 2004 was not placed with the court.
my lord, this the question.
Hmm.
Can legitimize the services rendered by the petitioner. There is no dispute for the fact that there is an OM which had prohibited the engagement. Or the fact of what would happen if an engagement was done illegal per se in violation of the OM is something that the lordship will explore my lord, and decide on this issue. That if a person qualified in the interest of the college has rendered services, can those services be completely wiped out? There should have been a bar at the entry of the employment. Fair enough, my lord. But the moment an individual enters, steps inside, and is asked and directed to render services, because the stand that we have taken, my lord, is that prior to starting of the degree in a college has to, on an ad hoc basis, my lord, start and continue with certain courses before a proper approval is granted by the Department of Higher Education, Bachelor of Higher Education. That is the stand that we take. We have not disputed that it was a sanctioned post. It was an unsanctioned post. Now the lordship will decide whether the work which was rendered can be nullified by an OL which did not place any fetters on her to seek employment. That is my submission. That is my submission. Some prosecution against the lordship and even then, there was at that point in time, there was a fetter under Rule 13, some civil services conduct rules, my lord, that nobody can prosecute studies without permission from the government. If your lordship in that matter, I categorically help you that the degree cannot be nullified because of the exemption for Rule 13. That your lordship had also captured the earlier judgments of the honorable court, but Rule 13 was not denounced or under the mother, but the degrees and the benefits that would come along with this degree would be applicable. Similarly, notwithstanding the presence of the OL with 2004, the service period rendered by the respondent number 6 may not be wiped out.
Yes.
I'm grateful.
Mhm. You go for respondent number?
It is 6.
6.
But I have prepared this matter was gave some written argument also. I'm just handing over it. My first point is, my lord, this definition is different. Why definition, my lord? Lordship knows after the selection is made by the selection committee, then governing body will have to approve it. Then governing body will forward it to the director for approval. Then only middle selection will retain some legitimacy. This stage has not come. All these stages, selection committee has recommended my name. My name has not been approved by the governing body. And director of higher education is also yet to. Lord, take a call on the recommendation of the selection body, which is being forwarded by the governing body. This is one. Number two, my lord, this 1 point issue, 1 point issue, this was already a subject matter of challenge in another case. My lord, the respondent number 6, presently she is working in AGP College, Dhaka. There also, my lord, this issue was raised and this issue was decided in my favor. So therefore, that issue has become academic. Now that issue cannot be reopened again and again. I'm just giving you brief. Third point, that there was an OM which prohibited, my lord,
Engagement in non-sanctioned course.
Now, my lord, lordship knows on this there are two arguments. One is this OM is not enforceable, as Supreme Court has said, my lord. And secondly, even if my appointment was illegal, my experience will not evaporate with them. It will still continue. This is my law, this law is called de facto doctrine. De facto doctrine will save my experience, my lord. My appointments will be illegal, but my will never evaporate. Now, my lord will kindly come to the writ petition. Our affidavit. It is come to, my lord, our affidavit at page number 19. The judgment.
Page number 19.
The judgment starts at 19. You have to lordship's kind attention to paragraph 4, 5, 6 and one later paragraph. And 20.
Of the earlier judgment.
Yes. Where this very point was hesitated. So on this point, my lord, there is already done. Where I was a party. Where my selection college was not the challenge of the ground. That experience could not, more experience, 1 mark could not have been given to me. Affidavit in opposition filed by respondent number 3, 4 and 5. I'm sorry. 3, 4 and 5, not 6.
Yes.
Let's come to paragraph 4, my lord, page 20.
Yes.
Application invited site advertisement dated 7 to 15 for filling up the aforesaid post of assistant professor in the Department of Sanskrit in District College, Nagaon. Petitioner and the respondent number 6 and many others responded to the same advertisement. On evaluation, the petitioner secured 68.43 marks and respondent number 6, that is the present respondent number 6, secured 69.37 marks, and accordingly, the aforesaid resolution was taken as respondent number 6 that secured highest mark among the candidates. The respondent number 6 was given 4 marks in teaching experience under the guidelines issued by the Commissioner Secretary to the Government of Assam and invitation by going with the 1 mark for each completed year of service in an affiliated government college, subject to maximum of 5 marks to be allotted under the aforesaid word. Para 6. The dispute herein lies in respect of grant of 1 mark out of the 4 marks. The principal of Mohendra Narayan Chaudhary Balika Mahavidyalaya had issued a certificate dated 8 to 15. The same certificate, which is now being pressed into service, saying that this certificate is of no value. Certifying that respondent number 6 had served for 1 year as adjunct teacher in Sanskrit in college in session 2019. This certificate was doubted and the contention advanced is that respondent number 6 did not render service for 1 year in the aforesaid Mohendra Narayan Chaudhary Balika Vidyalaya. The same contention has been advanced before your lordship also, that I have not served for 1 year. Now, we are trying to come to paragraph 20 and page 24. It is already indicated that respondent number 6 had for the first time drawn the salary in the month of September. Even if a service is record from the month of August 2009, she had completed more than 1 year of service as she continued to serve in the month of September 2010. Therefore, certificate dated 10/2/2015 issued by principal is a document based on original record which can be acted upon for award of mark towards experience. So the same very certificate 10/2/15, which is now sought to be questioned. Therefore, the grant of 1 mark on the basis of the aforesaid certificate produced by respondent number 6 cannot be held to be illegal and arbitrary. Milord, I understand, Milord, the present petitioner was not a party to this proceeding. But nevertheless, Milord, this very aspect was brought into by the coordinate bench of the Honorable Court. And the coordinate bench of the Honorable Court has recorded a finding that award of 1 mark based on certificate dated 10/2/15 is legitimate. So my humble understanding is, Milord, this point goes. Now let us try to understand the other. What are the other points? That there was a ban on appointment. If the lordship will kindly take the written argument which I have filed. If the lordship will kindly come to page 2. Capital A, I have dealt with why the repetition is premature. Because it has not been approved by the governing body. Governing body has not forwarded the resolution to the Milord director, and director is yet to take a call. Then please come to page 3B. Now please come to C. That the respondent number 6, having served for 1 year as ad hoc council teacher at Mohanbagan Chaudhary Balika Mahavidyalaya in Nalbari for the session 2009-10, she was issued the teaching certificate dated 10/2/15. Same result. Thereafter, respondent number 6 placed into service the said certificate while applying for a similar post of assistant professor at ADP College, Nagaon. The respondent number 6 was selected to the same post as seen on the merit list with so and so much. Another aspirant to the same post, Sri Chandan Hazarika, was 16.43 marks approved in Honorable Court by the invitation. And saying the none of this I have already told you, I will not travel your lordship. Now please come to D regarding ban. That as regards the contention of the writ petitioner that respondent number 6 is not entitled to 1 mark as teaching experience as an appointment was made with ban period imposed by where the is submitted, that state contention is already discussed and as such deserves to be rejected outright. In this regard, it is also stated that it is a right now that teaching experience as envisaged under OM dated 25/6/12 is not dependent upon the nature of appointment. It is nowhere stated in the same OM that teaching experience gained after regular appointment shall be considered and such experience gained on ad hoc appointment shall not be considered. Teaching experience gained in ad hoc or such nature of appointment is also experience and warrants value consideration. So one aspect is, my lord, that teaching experience, whether it is on a substantive post or it is an ad hoc post or a temporary post, its nature of appointment does not, determine the teaching experience. Now, there are 2 judgments. One is Dilip Kumar Sharma, our High Court judgment. Then Ashwin Kumar Bose is the Supreme Court judge on this point. Whether once an incumbent gains experience, be it in a substantive post, be it in a temporary post, be it as an ad hoc post, it will still be experience. Now regarding the ban, the please come to E. That even assuming while not admitting that appointment of respondent number 6 is illegal in view of the ban imposed by OMD, then in that event also, teaching experience gained by the respondent will be said by application of de facto doctrine. According to this doctrine, acts of officers de facto performed within the sphere of their assumed official capacity in the interest of public or third parties are generally held valid and binding as if they were performed peacefully by officers. For instance, when the Honorable Supreme Court of India held appointment of district judge in state of Uttar Pradesh to be illegal and struck down the same. Subsequently, the Allahabad High Court in Jai Kumar so upheld the judgments of the district judge on the principle of acts of those officers de facto are not to be questioned because of want of legal authority. Another example is the act of officers whose services have been terminated as illegal appointment in ongoing APS scam are saved by the virtue of the same doctrine. The same proposition of law finds favor of the Honorable Supreme Court in so versus so. Therefore, by application of the same doctrine, teaching experience in question of the private respondent number 6 would be safe and remain valid even if their appointment is held to be bad in the eye of law. So, my lord, effect of doctrine will save as if the duty was performed easily, even if the appointment is illegal. So, the gentleman have brought me, lord. Osin Kumar, Bose and Dilip Kumar Sharma are for that experience, my lord. But if lordship would kindly have the judgment, please have 1991, my lord. 1991 1 SCC 319.
Yes.
Now, let's come to page number 324, Milord. The last one, Milord, the de facto doctrine has also page number 324. The de facto doctrine has two images, namely the last page number 324. Last sentence, there are two words, the de facto. The de facto doctrine has two images, namely possession of the office and performance of the duties attached there. Color of title that is apparent, right to the office and acquiescence in possession thereof by the public. According to this doctrine, acts of officers de facto performed within the sphere of their assigned official authority in the interest of public or third parties and not for their own interest are generally held valid and binding as if they were performed peacefully. Then below we kindly come to the President C. The sentence starting the Allahabad High Court in Jai Kumar versus State. President G.
Yes.
The Allahabad High Court in Jai Kumar versus State upheld the judgment of the district judge whose appointments were later struck down by the court on the principle that acts of officers de facto are not to be questioned because one of legal authority except by some deflect proceeding instituted for the purpose by the state or by cycling to the office declared. Or except when the person itself attempts to build up some right or claim, some privileges or benefit by reason of the officer which it brings. In all other cases, the acts of the officer de facto are valid and effectual while he suffered to retain the office as though he were an officer by right and same legal consequences follow for them for protection of the public and of the third parties. So one of de facto doctrine is the doctrine which is normally applied in such a situation. Even if the appointment is held to be bad, but the acts are presumed to be done legally. So therefore, my lord, the entire interpretation is absolutely only responsive. Number one, it is premature. The decision is yet to see the light of the day. Number two, my lord, the issue of 1 mark is already adjudicated by coordinate bench of this honorable court. The same very certificate dated 10 to 15. Number three, my lord. Oh, that redundant record. Number three, my lord, experience, when it comes to experience, it is immaterial whether the experience is gained on a substantive capacity or an ad hoc capacity or temporary capacity. experience is experience, where I have already indicated the two judgments there. Then we have this validity of this OM. It cannot be enforced in a court of law. That judgment I placed there. 2007 8 SCC 212, para 20. These OMs are never enforceable. These are the guidelines. Para 20 at page number 221. It's on page 221. It is well settled that the central government or the state government can give administrative instruction to its servant how to act in certain circumstances. But they will not make such instructions statutory rules which are justiciable in certain circumstances. In order that such statutory instructions have the force of statutory rule, it must be shown that they be issued either under the authority conferred on the central government or the central government by some statute or under some provision of the constitution providing therefore. Therefore, even if there has been any breach of such executive instruction, that does not confer any right on any member of public to ask for a writ against the government by petition under Article 26 of the Constitution of the Union. In fact, the law in 1970s, this proposition was laid down by the Supreme Court. So these are not only for the guidance. This does not confer any enforceable right. So therefore, Lord, from whatever perspective we view at this matter, this is entirely only celestial responses to this. Now the 20 years now, my selection has been withheld for no ostensible good reasons. It's a case where ostensible distance doesn't have any merit in the petition. That is my humble submission. Lots of kind permission, I have mattering purpose.
Let me deal with the last submission.
That this OM is not enforceable. It is he who came to this court to say that this OM need to be applied. Yeah, but so that is the draft case.
Now, when the response number 6, file the writ petition. How can the person go and pull that much? Page 48, the judgment starts. And your lordship will kindly come to page 59. In fact, if your lordship takes up para 4, page 50. Third line from top. The petitioner was agreed in as much as the office memorandum dated 25/6/2012 held the advertisement did not provide for holding any interview, and as such holding the interview was prescribed by the OM dated so and so in the aforesaid premises. The requisition has been preferred for setting aside this election that was held on so and so with a further direction to hold the fresh election strictly as per procedure laid down in OM dated 25/6/2012. Now it is the same person who is saying that this OM is not enforced. She came before this honorable court to have this OM enforced, and that prayer was allowed. Now it is the same person, respondent number 6. At that time, her whole case was that this OM should be applied. And that is what was available. And now, when it does not suit her, he says that this is not whether you're working with the comments or not.
No, one decision is cited.
Lordship sees the judgment. It is in the context of transfer and posting. Otherwise, the law is very clear. When the rules are silent,
It is the executive instructions which work with you. There are hundreds of judgments on that.
Hmm.
When we are talking about issues like transfer and posting, there the Supreme Court says that these are for merely guidance of the officers. Therefore, transfer, posting, OM are not enforced. But here, this is an OM which prescribes the procedure of selection. Here, that principle will not even have any application because the rules are silent as to
So how the marks will be allotted?
the rules are silent as to how the marks are. So to that extent, there is a gap in the rules. That gap has been filled by this OM. This is executive. So therefore, it will be enforced. For all intents and purposes. On that matter, I did not carry any judgments.
But if your lordship so desires, I can
Place one of
judgments.
It is a settled system of law that when rules are cited, the executive instructions can fill up the lacuna. And it will become, it has force of it. That is the first answer. Second answer is also in that paragraph 4. Now they say, when it suits her, now she is raising the argument of premature. If this writ petition is premature, the writ petition filed by her as petitioner in this WPC number 6428 also would have been premature. It's a complete classic
Case of a person blowing hot and cold.
where it's here the director had not approved. It was as soon as the interview was held, she rushed to the court. So the same principle will have to be applied. Identical selection process. In fact, the same selection. This is the answer to this aspect, premature aspect. And the answer to
The de facto doctrine,
greatest respect, my lord, de facto doctrine is a complete different concept of it. Just to give an example, what is de facto doctrine? I will place the same judgment makes the position very clear. The de facto doctrine,
I will
try to explain with an example. Assuming a judicial officer has been appointed. And that appointment is challenged as being illegal. Till the courts decide about the legality or otherwise, the judicial officer will continue to serve, he will pass judgments. Those judgments will be saved. But the legality or illegality of the appointment will never be saved. That's in fact my senior colleague placed this judgment. The answer lies in that same judgment. 1991, volume 1, this is 319. You will kindly come to paragraph 5. It's a very long paragraph. I will not trouble you with the whole paragraph, only the relevant. Your lordship comes to paragraph 5 and page 324. Right at the bottom, in the last line, there is a sentence starting, the de facto. The de facto doctrine has two requisites, namely, number 1, the possession of the office and the performance of the duties attached thereto. Number 2, color of title that is apparent right
to the office
and
acquisition.
in the possession thereof by the public. According to this doctrine,
The acts of the officers de facto
within the sphere of their
assumed official authority in the interest of the public
or third party and not for their own interest are generally held valid and binding as if they were performed by de jure officers. So, in this particular example, if she has worked for a period of 1 year, any document she has signed in the capacity of a teacher, ad hoc, teacher serving on ad hoc basis, if she has corrected some question answer script, all those actions will be valid. But her appointment will not be valid. That is that if your lordship kindly comes to the bottom of the page again, page 325. The last part, one line from bottom. Code in Gokaraju Rangaraju versus Steno Baby was required to consider the question of the effect of the declaration of this court holding the appointment of an additional session judge invalid on judgments pronounced by him prior to such declaration. Exactly the same example that I was giving you. So this additional session judge appointment was invalid. So
The question that arose was, what will happen to the judgments passed by that additional session judge?
this is how the court can. This court observed that the de facto doctrine is founded on good sense, sound policy, and practical experience. It is aimed at the prevention of public and private mischief and the prevention of public and private interest. It avoids endless confusion and needless chaos. It
Therefore, seems clear to us
that the de
invoked in cases where there is an appointment to an office
defect, but notwithstanding the defect
to the title of the office, the decisions made by such a de facto officer
to the powers and function of the office would be as efficacious as those made by a
de jure officer.
So all the judgments passed by this additional session judge would be safe. Till it is held to be invalid. In fact, in paragraph 6, line number 5 from bottom, this sentence makes the position very clear. There is a sentence starting, but the doctrine. But the doctrine does not come to the rescue of an intruder or usurper or obtruder stranger. So basically, the legality or otherwise
Will not be saved.
what will be saved is the actions taken by the
Person.
while holding the document. She must have corrected some answers. She must have signed some documents. All those documents will be deemed to be valid under the de facto process, but not her appointment. The appointment will come because there was a ban. Our appointment cannot be legal. That illegality will come. And the question of law that arises in
This case,
my humble understanding is that if the appointment is illegal, can that one not
be awarded.
for an illegally made appointment? It is not a question of whether she was on ad hoc basis or this or that. That does not matter. This
OM
of 2004, 12/10/2004, imposed a ban on any appointment against non-sanctioned post. And here is a case,
admittedly,
till 2022, when
the RTI reply came
there was no sanctioned post of Sanskrit in this college. So therefore, assuming she was appointed on ad hoc basis, assuming she has rendered her service, her appointment still remains illegal. And against an illegal appointment, whether that one mark can be not. In fact, in any case, whether this de facto doctrine would not come to the, it would save only the action of the appointment. That's why. And so far as the judgment
is concerned,
in that Nagaon College judgment, there admittedly this issue has not even ended. 12/10/2004, web issue was never even an issue. And on top of it, I was not even a party. So how can that judgment be applied? And there are, in absence of that submission, in absence of that fact, that judgment becomes
not only substantial but also parental.
this.
So
Therefore, my respectful submission.
he already handed.
Heard, Mr. Aisodore, learned senior counsel assisted by Mr. Hazoika. Learned counsel for the petitioner. Mr. Ken Sodore, learned counsel for the respondent number 6. Respondent number 6, assisted by Mr. Patwari. Jay Patwari. Mr. S. Das, Learned Standing Counsel for the respondent in Higher Education Department. Mr. M. Sormapo, respondent number 798. 798. Argument completed, judgment reserved.
Just one clarification, my lord. As the part is not for appointment, it is for experience.
Yes. If the appointment goes, the experience obviously goes. That's why maybe 320.
Experience will remain.
Experience is not saved. The actions taken is saved. The de facto counsel.
Let us fix that to here. Item number 20 for motion.
First, the assumed order matter which is there, that is 8/7/2025. That is 7/7/2025, which is the
So, in this file, where is the order of extension? Last page.
Information technology, which there is a notification stating that from the 29th to the third, there will be a server will be down, but the server was down till the 8th of October. That is why, my lord, the 4th of October, the review was done. It was already placed on the last occasion. The query was from the court whether why it was not physically signed. Query of the court was, my lord, that the petitioner had put in was the query. Order was not physically signed. Therefore, my lord, which I produced, notification of the information technology department. We think that there was a server down, my lord, because of African agency. It is already there in the record also.
Only the to when the order was issued and I did not receive that order. But I received it on the 28th of November.
I learned one more thing I learned to point out. On 8th of July, he was suspended. 8th of July, 2025, which is undisputed. And then, my lord, the first 90 days happens at 9th of October, 9th. And whereas he was, if Lordship sees, he was extended at 4th, which is literally, my lord, before the commencement of the 90 days, technically. And so now, my lord, since that has been reviewed properly, now the next date is on 4 and that's the point. After 89 days, we have been fixed. And July had 31 days left. Incidentally, on August 36.
So now focus notice was issued to her. Replied.
Suspension order or which is the evidence, it is said as a
I know my friend said something, I don't know what my lawyer has come to the conclusion. Only one thing, my lord, I just. My lord was fixed on the order 12/11/2025.
11/2025. Right one.
As they have put for my lord.
On 18th, they've issued the show cause. My lord, that letter is before my lord, I suppose.
Okay, we will see. If the review is done within the stipulated period of 90 days,
It goes. I just.
My lord, got it. My lord, they have produced that.
Papers regarding the extension.
It is in the loose sheet.
That was provided to.
yes, 1811.
So, my lord,
This is their document. The 8/7/2025 suspension order is passed. My lord, that 8/7. This show cause with statement of allegations.
So that is beyond 3 months. Now the question is.
On 4/10, they are saying that they have reviewed.
They have reviewed or not, I don't know, my lord.
Still, it's doubtful for me because
I did not see when 89 was served on me by the office of the BEO, SP of the BEO, his name is Dikal Goran. 1811 was served on me on 1911. Incidentally, 4/10, this is review was served on me next day, 2011. Without any fee on book. Then only the suspicion arose. But the fact remains, on 1811 they have given. Now see, my lord, Ajay Chaudhary's para 14. In pursuance to
that the office memorandum which was issued
just
allowed to be continued or it should be revoked. Reviewing their.
Which paragraph?
It is therefore directed that all the senior most
Secretaries of departments
shall ensure that the memorandum of charges, public charge sheet is served on the
delinquent officer employed before the expiry of period
from the date of
issuance of order of suspension. It is their OM.
So that in fact, 90 days comes on 6th October. So what it says, the memorandum of charge should
Be
served on me before 6th October.
now
They shall also ensure that the currency of the suspension order should not extend beyond
3 months. In this period,
the memorandum of charges charge sheet is not served on the delinquent of the employee. the memorandum of charge sheet is served within 3 months of suspension, a recent order must be passed for the extension of the suspension wherever necessary. That means what, my lord? What they are saying, the review on 4th October, the record has been called. Incidentally, before that order, the charge memo had to be submitted to me. Otherwise, this question of extension of suspension doesn't arise. This is Ajay Chaudhary said, and if your lordship looks at the first para, the Honorable High Court Guwahati in its order dated so and so in a series of writ petition, the lead case being W so and so has directed notification. The law laid down by the Honorable Supreme Court in Ajay Chaudhary versus Union of India is to the effect that the authorities comply from the date of issuance of order of suspension. Admittedly, this is their document they have served on 1811, just after about 5 months. So on that count itself, this suspension goes. As simple as that, my lord. The one thing that may come, we have reviewed before. Then given the charge memo asking him to 2%. That is not tenable in law. Neither is tenable. Taking the Ajay Chaudhary's case and their memorandum dated 4th February 2020. What it said, you issue the suspension order. 90 days first you give the charge. Then if necessary to continue the suspension, you pass a reasoned order. This order which 4th October is not a reasoned order at all, but considering the charges, my lord, that is another aspect. Because when I looked at charge memos are admittedly served on 1811, that is their order. I received on 1911. So this is after 5 months. That is 2 months, almost 2 months after issuance of the first. Then, my lord, further suspension on this count alone.
Okay.
The lordship comes to this order, which comes to 21/11/25. The order. After the first order, you mentioned 21/11/25, the instruction as to whether review was done or not. Accordingly, instruction of place that review was done. 21/11, your lordship comes to 21/11. Review order has been placed before the court. Then, my lord, the issue is regarding that review has been done, but digital signature has not been done. Upon the result of the order, in terms
Okay,
of the last order,
you have done the review on 4/10/2025.
Exactly, madam.
But is it in compliance of this OM issued by the Chief Secretary?
Not, my lord. Authenticity of the order is saying that
No, that's all right.
Then, my lord, then the next occasion I have I had appeared for the first time. Then, my lord, I've got the record saying that there is a office notification. I mean, notification for the technology department, which are given, which is the record. Which says that, my lord, the
Okay.
that was fine. That was done. So that regarding the signature, so it is fine. And review was done on 4th. And if your lordship sees also, if your lordship sees 8725, you can place it. 8725 is the order suspension. 9 days happens. Take the 9/26. It is 90 days happens. So our review was done on the 4th. Prior to
commencement of the 90 days. Technically, for Chaudhary, we are,
Oh, all right, all right.
so we are in the Supreme Court. judgment. We have done the thing, he is saying that it's not a reason order. The lordship will decide whether it's a reason order or not. If that the review is not reason, so but we, so as per our memo records now, the next thing will be.
No, his contention is that as per this OM, before expiry of the 90 days, you have to serve the memorandum of charges.
But we have reviewed it, madam. We have reviewed it.
No, still you could not follow the matter, could not follow the issue. So have you, this office memorandum is before you,
My lord, at the moment, I don't have.
4th of February
Let me get
2020.
Instruction regarding this. Then, my lord.
What instruction is required? You
Regarding-
go through it?
No, but that was-
No, if you issued the memorandum of charges
My lord.
on 18/11, whether it is within the period of 90 days, that is a simple calculation.
I don't want given, I think.
Pardon?
The record, the lordship checks it up once.
Yes, it is issued on 18/11. But what is stipulated in the OM? You see the second paragraph?
Therefore, directed that so the before expiry of the 3 months, before expiry. So it can expiry.
8,
Probably.
and you issued in on 18/11.
That we need to check the dates.
You see your record, you have produced that document.
I'll check it up.
This you have furnished the
Not furnished. This is a show cause notice.
Mm.
on the next page. Allegation.
Notice along with the allegations, and based on this matter, he has given a reply also.
Mm.
To this he has given a reply.
Mm.
I don't know.
This memorandum of charge,
Yes. This is after.
search it.
Yes. Sir. This is, my lord, exactly what my lord after the 90 days.
Mm.
According to the, my lord, Chaudhary, which is in the form of this memorandum now in the year 2020, it shows that memorandum of charge has to be submitted to the billing officer before the expiry of 90.
Okay.
As clear as that.
Okay.
Yes, my lord.
Mr. Fokon, you see this letter dated 18/11/2025.
I see.
The letter dated 18/11/2025 is a search sheet.
Madam.
Here, as many as 3 charges have been framed against her. Following charges, you see the third line. The following charges based on report of the DIS, Tezpur Bhait, letter dated so and so, so and so. So this is the search sheet. This search sheet is filed on 18/11/2025. And copy was served to her on 19/11. So whether the suspension order will stand in view of this OM and whether this OM is complied with.
I'll leave it to your lordship. Helpful to your lordship.
No, see, this is the OM issued by the Chief Secretary. And issued person to direction of the Supreme Court as well as of this court. Yeah, we will pass the order.
Number 6.
Pardon?
Base annexer.
Your service book is part of the record?
Yes, yes, my lord. Your
Page
lordship,
number?
go to the page. Page 80, your lordship. Page 80, my lord. Particular, page 80, my lord. Page about your lordship. Page 80.
Yes.
Draw regular time scale of pay. Pay are the bits 5,200 plus 1,500 rupees. So in just basic, I ordered the regular scale of pay. But it is not received by the graduate scale of pay from 6 to 2012, my lord. And start paying 82 crores, if you put 82. Revised scale of pay with effect from 1/4/2016. The pay rupees 14,900 as per rupee 17 by so. Respondent stated that, my lord, I have received my regular scale of pay 2016, but it's not correct, my lord. I received revised scale of pay with effect from 1/4/2016. And regular scale of pay is 86 to 2020. I received the regular scale of pay as a graduate teacher with effect from 6 to 2020. But they stated that no, we are receiving graduate scale of pay 2016, that is the revised pay, revision of pay, my lord. Revised scale of pay. That is the main issue, my lord.
So where is the impugn order?
Impugn, my lord, your lordship. Page 64. 64. Go to 65. Second para, my lord. As per written statement submitted by the inspector of school by joint dated 2003, Ojit Das was initially appointed as the officer. So created by so under OBB scheme. Later on, his post was regularized by government order number 21/2010. After completion of DA died, he was allowed to draw prescribed scale of pay by the report by regular dated 6 to. Thereafter, he has been drawing salary allowance regularly as per rule. As per drawing grade pay. My lord. As per record, Ojit Das has been drawing greater scale of pay full effect from 1/4. That is what wrongly stated, my lord. Actually, we have received regular, my lord, revised pay scale full effect 2016, and the regular graduate scale of pay was received from my lord 2012, my lord. 6 to 2012. That was my lord not. So I said the report for it. Your lordship.
No, in the page number 80 of the service book, it has been mentioned that you have been granted a regular scale of pay. Where it is stated that you have been awarded the graduate scale of pay.
Because of that, my lord. Your lordship, go to my lord. Page 74. This is the Assam Service Division of Payroll 2017, page 74. Your lordship. Assam Lower School Service Teaching Inspection, so MB, Headmaster MB, next graduate teacher, paid 5,200 to 2,000 to 2,000, so 2,000 is the graduate scale of pay. I have received the graduate scale of pay.
Okay.
The graduate teacher scale of pay 5,200 to 2,200. That was received by as per my service book, your lordship. 5,000.
Okay. Yes, Mr. Sharma, what is the stand of the
Go with this book also, my lord.
Okay, not necessary.
That is also for a graduate teachers, size teacher. That is the my lord.
Okay.
5,200 to 2,200, my lord. And response number 2, my lord. Inspect of schools, my lord.
No, Mr. Bora,
My lord.
you have been awarded great pay at the rate of rupees 2,500. And 2,500 great pay is awarded to the junior undergraduate teachers.
Yes, madam. I was appointed by the OPB teacher 200.
But this scale is for undergraduate also.
Yes, madam. Your lordship, go to the graduate teacher scale of pay 5,200 to 2,200. That was received by me as per service book, your lordship, go.
So since the year 6 to 2012, since the year 2012, you have not been drawing the graduate scale of pay, that is the grade pay of 2,700. You have been drawing the intermediate grade pay, that is 2,500.
Yeah, after completion of my DLED,
Hmm.
as per regulation order, you also go through one by one, then minus.
Is it part of the record?
Yes, page minus your lordship, page 35 and next 5. The regulation order minus. But part of the one of 2010. Page and next 5. Initially, I was appointed as a OBB pilot 2000. Thereafter, I was asked by page 35 below pilot, still number 2 pilot. Got it? This teacher will under basic normal training from the current academic session. They will be entitled to enter prescribed pay scale as per ROP 2010 from the date of passing training. As per Education Policy 1977, 2005 minus. And my name is serial number page 37, serial number 225. And thereafter, my lord, page 39, exercise 6. Immediately on receipt of the regulation adjustment order, state teacher OBB so the same will be reported to the school director. It has been posted there and will be reported. So it shows. Thereafter, my lord, I have completed diploma in training 2000 minor. 2010 minor and 2012 minor page 49 and page 41. Regarding allowing the draw pesca to the OBB 7, this is letter number, so it's DDO wise and wise backup OBB under primary teacher under institution for allowing draw pesca scale pay to the teacher concerned for favor of necessary action minor. And I have received the same minor. My name is serial number 8, page 44. And thereafter, page our school was amalgamated to the high school. Page 45 and extra 9.
No, you show me the order by which you have been granted the graduate scale of pay.
That is my lord, dear my lord.
Where?
Actually, my lord, I have received the page 9 my lord. And extra 9 page 45 my lord. I scale of pay 5,200 to 2,200. This is the graduate scale of pay.
No, no,
Yes, scale
that scale of pay is granted to the undergraduate teachers also, but the difference is only the grade pay.
Grade pay.
You show me from which date you have received the grade pay of 2,700.
No.
Grade pay. That is the scale.
My
Is there any order granting you the graduate scale of pay?
that is they are given the pay scale by law. Pay scale after completion. Graduate scale as a science scale. They are all science graduate graduate scale of pay.
Which one?
All any school by law, that government is.
Where is that order?
Yes, madam. That was also written in the section 9 page 45. That is also the scale of pay. They 5,000 2,000 times. And If honorable court, your lordship go to the affidavit by the inspector
No,
of
no,
schools.
you show me by which graduate scale of pay was granted to you.
That was the order was passed by the inspector is also thereby honorable court regularly, my lord, earlier occasion, my lord, regularly. Stated that, my lord. All the instance of my lord, the honorable court permit me also, but. I took 2004, orders to directly tax. That's what I'm authority, because of that. They have my put my. That was my.
No, your service book is there, but
So thereby you lordship go to the affidavit by the inspector of school pays 90. Still, but prepare no type. And it was also.
you see, come to page number 68.
Yes. Did the.
Issued on 1/4/2016, and from this date you have been granted the grade pay of rupees 2,700.
That is the my lord, revised pay, my lord.
Hmm.
That from which revised pay structure, my lord, 1/4.
No, you show me any document prior to 1st of April 2016 to show that you have drawn grade pay of
My lord,
rupees
that
2,700.
that order was reflected in the service book that is issued by the 6 to 2012.
Hmm. At page number
Page number 80, my lord.
80. 80, here you see grade pay.
Allowed to draw regular time scale of pay.
Here GP is grade pay is 2,500.
Yes, madam. That is the revised division of pay, my lord. 5,000 pay, my lord.
Hmm.
That is the base 150.
GP here GP is 2,500, whereas GP for the graduate teachers is 2,700.
5,200, my lord. Graduate teachers is senior basic
No, no,
school,
grade
my lord.
pay.
Hold on. Is there.
You come to page number 80.
80.
80. 80.
Same matter also. The graduate teacher. man. So that was his receipt
No.
by on 6th.
No, no. Grade pay here 2,500. Then you come to your own document.
Yes, and allowed to draw regular time scale of pay. Rupees. Regular. 5,200 plus.
You come to page number 70.
500. And regular is the service.
No, Mr. Bora,
My-
you come to page number 74.
74. Yes.
Graduate teacher.
5,200.
Grade
Yeah.
pay.
Yeah.
This grade pay is 2,700.
Yeah.
So on 6/2/2012, your grade pay was 2,500. That is the grade pay of undergraduate teachers.
Next rupees 5,830 plus 2,500. So and so 8,330.
Now come to page number 74. After the graduate teachers, junior undergraduate teachers, This pay band is two, pay band two,
To 5,200, 2,700.
2,500. Undergraduate teacher.
Yes, that is 2,000, my lord. And my lord,
No. This a grade pay 2,500.
no. So your lordship clarified by the TO, page 90 of the affidavit of.
Yes.
Para number 5, my lord. There your lord, deponent begs to state the petitioner of the incident case was initially appointed as secretary on 8/3/2001 and fixed pay of rupees 2,000 per month by the district education officer Sunitpur post created by government under ODB scheme. Later, his post was regularized by government under 21/10/2010 and adjusted again post of state teacher by KSO so. After completion of the diploma in elementary he was allowed to drop that scale of pay by the district elementary education officer Sunit by letter number so and so regular scale pay so and so on 6/2/2012. My lord. Thereafter, he has been drawing regular pay and allowances with grade pay rupees 2,700 till 2016. 2,700. As per Assam Service Revision of Pay 2010 rule, my lord. And so and so with effect from revision of pay, my lord. 1/4/2000 Assam Service Revision of Pay, my lord. 1/4/2016 as per the Assam Revision of Pay Rule 2017. And I also given that is the revised pay, my lord. I file and reply, my lord, regarding that, my lord.
Where is your reply?
Reply, my lord, please. Page 97, man. Para 5, my lord. Middle line, my lord, your lordship. 5 and 6, my lord. In the list of enclosed with the said letter dated 6/2/2012, the name of the department shown as serial number 8 bearing serial number list 179. Accordingly, the department was allowed to draw the graduate scale of pay with effect from date of passing DLED course from DICE, Sunitpur, and department received his graduate scale of pay with effect from date of passing DLED course from the DICE, Sunitpur. That as regard the statement made in 6 of the affidavit of opposition filed as 3. Begs to say Deputy Secretary Government of Assam by Department to forwarded before the Secretary Assam Pay Commission and memorandum submitted Assam Pay consideration of the graduate scale of pay. The graduate assistant teacher serving a middle upper primary school under Director Elementary Education. Department further begs to state that in the memorandum enclosed with the said letter 24/12/2008, it has been observed that all Assam middle graduate assistant teacher Koilan Committee had submitted WPC number so Honorable High Court and High Court by order dated observed that the petitioner association named All Assam Middle Graduate Teacher Koilan Committee, which is registered association, has filed the instant writ petition application for a direction provide them to the graduate scale of pay. All the members of the committee are graduate teachers in various provincialized so-and-so school Assam. The members of the petitioner association have also stated that they have now been discriminated as they were not been given graduate scale of pay, which have been given to the science graduate teachers working in the same ME school. the members of the petitioner association have given the scale of pay 1185 per month, whereas science graduate teacher have been given scale of pay rupees 1375 per month. This has already deal with this court civil rule number so and so, holding that since the science graduate teacher have been given graduate scale teacher, there is no justification to deny the same benefit to the petitioner. The government of Assam by notification dated so and so also given all existing teacher with intermediate scale of pay so and so.
Okay, okay,
And my
Yes.
lord,
okay, Mr. Bora,
my lord,
Mr. Sharma.
and my lord,
See
your
the
lordship, your lordship, I'm filing also page 114. This is the
Okay, Mr. Bora,
my lord.
I'm asking one question to him. Page number 99. The affidavit in opposition filed by the respondent number 3, the inspector of school.
Number
99.
it is filed by the director.
No, no. Respondent number 3 is the inspector of school.
Yes, madam.
This affidavit is by, oh, sorry, this is by the director.
Yes.
Respondent number 2. Here you see the page number 99, it is
Yes.
stated that the petitioner was drawing regular pay and allowances in pay band 2 with grade pay rupees 2,700 till 31st of March 2016,
Yes.
right?
Yes.
2000, here grade pay of rupees 2,700 is the grade pay of graduate scale.
Yeah. As far as it is,
Yes. As per page number 74.
it's not 74. Yes.
Graduate teacher.
2,700.
Yes, 2,700. And as per your, as per the stand of the director,
Yes.
the petitioner has been drawing the same
Yes.
since 6/2/2012.
Yes. And he was appointed as intermediate teacher.
Maybe.
Yes, he was not appointed as a graduate teacher of graduate school. He was intermediate teacher.
No, no.
He may be obtained graduate degree, my lord, but he was in graduate, he was in intermediate scale of pay.
No, you see,
Science
from
teacher.
this date, he has been given the graduate scale
Yes.
with grade pay 2,700 rupees. Page number 99 of your affidavit.
Yes, madam. Madam, may I draw your attention in affidavit in opposition filed by the respondent number 3, madam.
Page number
3. No, respondent number 3, and page 91. Already my line item, has already, resolved from the side.
paragraph number.
Page number 91, serial number 6. Thereafter, the petitioner has been drawing regular pay and allowances of pay then to 5,200 to 2,200 with rate pay at the rate of 2,700 till 31/3/2016 as per the Assam Services Revision of Pay Rules 2010.
Yes, revision of.
And in payment to 14,000 to 14,900 with get pay at the rate of 8,700 with effect from 1/4/2016 as per Assam Service Revision of Pay Rule
Yes.
2017. Madam, serial number 7. That your deponent begs to state that.
No, no. Mr. Sharma. Now you come to page number 66. The impugn order.
66.
The second line.
Yes.
As per record, Ojit Das has been drawing graduate pay, scale of pay
Yes.
with effect from 1/4/2016.
Yes.
And what is stated in the page number 91?
Till 31/5/2016.
Till 31/3.
Yes.
That means after 6/2/2012, he has been drawing this graduate scale.
Graduate scale of pay. My lord, this
No,
was
no,
my lord, the
you see.
revised pay. 2007.
No, you see the contradiction in the impugn order and the affidavit filed by you.
Paragraph number 7 can be come.
No, you see paragraph number 6
Yes.
and and page number 66.
Yes, madam.
Here you have stated that he has been drawing this grade pay
Yes.
till 31st of March 2016,
Yes.
and 2,700 grade pay is the grade pay of graduate scale.
Yes. Here in the 68, page number 68.
No, you answer my question.
This is revised pay starts.
Which one?
Page 68, man. And come to the-
No. You first come to the impugn order, page number 66.
Yes.
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 But what is stated in paragraph number 6, page number 91?
Page number 91, prisoners going regular pay and allowances in given to minor factor which mandatory 20,200 grade pay of 2070. 731,616 and as per Assam division rule of 2010.
So from which date he has been receiving it? From 6/2/2012? The last line of paragraph number 5. Thereafter, paragraph number 6 start with the word thereafter. It means after 6/2/2012.
Yes.
And you come to page number 66 with effect from 1/4/2016.
Yes.
So is this impugn order is based on the correct facts?
Can we come to the paragraph 7, madam?
No, you first explain it. Hmm?
Two.
You
Affidavit in
no.
reply on.
You see page
Yes.
number 74. The grade pay of intermediate teacher is of 2,500.
Yes.
Page number 74.
Yes.
And you come to paragraph number 7 of page number 91.
Yes.
Here it is mentioned that both are entitled to grade pay of rupees 2,700. From where do you got it?
But after getting the 2,200, it was revised, madam.
Hmm.
2016.
When?
Madam,
Page number 112 of affidavit in reply filed by the affidavit in reply in response to response filing affidavit in opposition filed by the respondent number 3.
112.
Yes, my lord. 7252000 2300 and my lord here on next page 2300 to 2700. This is the revised rate approved by the government by notification number 12, that is 19 to 2011.
Page number
13. But as well as pay was 3,300, is 5,200, 20,200, 3,300. And
Oh,
it is
that-
clearly stated in paragraph 7, my lord. In our affidavit filed by the respondent number 3.
Page number
19, my lord, 113.
no 113. There is no scallop.
113 of affidavit in reply in response to respondent number 2. Affidavit in opposition, respondent number 2.
Which paragraph it is mentioned?
Second paragraph, page 1, and it is serial number 9. Annexure 8.
It's a more reply. 112, ma'am. With notification, my lord, 1111. Train and graduate teacher, PMN to 5,200 to 2020, 2,300. Train and graduate teacher, my lord.
No,
One-
here it is the pagination is mismatched.
It's the free long of the release.
Reply.
Page 107, my lord, it also got it, my annexure A. Affidavit in reply. 107. Graduate scale of pay to the graduate assistant teacher of middle. Forward here with a memorandum to be submitted. Considering the graduate scale of pay. Serving under middle upper primary school after the director of elementary education Assam.
So the
Nation of something. 116. Mine is 107. That is what number 116. Like more different than my presentation of the absolute. Page two. Page one was 12 of the same item. Trade and gadget teacher. Okay, yeah, next slide.
So which scale is given to the graduate teachers here? Payment group.
5,200. Payment to 5,200.
Serial number.
Minus 74 page.
For the intermediate teacher, it was 2,700, and for the graduate teacher, it was 3,300. So it
No,
was
no, no, no.
clearly mentioned in our affidavit filed by the.
No, no.
Paragraph number 7.
So whether this page number 74,
My lord.
where the scales are mentioned, are modified by the government subsequently?
Yes, my lord. That is the notification is there, my lord. I'm so I must state it, my lord. Page
No, you see,
107.
this page number 74
Yes.
was published in the Gazette
Yes, ma'am.
on March 17 of 2017.
2017, my lord.
And page number 113, which you have mentioned,
Yes.
that was published or revised by notification dated 19/2/2011.
11, yes.
Which one is correct?
11 is correct. 12, I've got my lord. Scale of pay. This is the my lord. I'm receiving.
This 17, this 17 notification, Gazette notification. Page number 74.
My lord, my all designation is my lord wrong, my lord. That is not daily, my lord.
No, you see, this is the Gazette notification.
Notification page
74.
What is it? 74. Oh, no, no, no.
74 of the writ petition.
Page 126 in my reply, your lordship, my lord, that is on 24 December.
No, no, you come to page number 74.
Or 74 in my petition.
Yes.
Yes, my lord. That is the graduate teacher, higher secondary, last bit, my lord.
So this scale,
5,200.
this scale was published in the Gazette on March 17, 2017.
This rule is 2017 rules, my lord.
Hmm. And this annexer I at page number 113.
Yes, my lord.
This is of
Regulation order, my lord.
no.
Annexure 5 of my writ petition.
No. Page number 113. The scale.
One, 2, my lord. This is the one Tipula, my lord.
You see, applicable with effect from 1/1/2011. Got it?
The notification dated 4th February 2010, lordship.
No, no. Sorry. Seventy-four.
Or rules, my lord.
Scale of the gazette size scale to it. Get
17 March, so this is the revision of pay, my lord. That is revision of pay, my lord. Assam Service Revision of Pay Rules 2017, including revised pay structure schedule. Department wise, it was a 17 March 2017, the graduate teacher pay went to 5,200, 2003. Matter may be taken up Thursday, my lord. In the meantime, I will, my lord, correct my lord. This is the problem, my lord. Otherwise, my lord, our presentation is different, my lord. Tomorrow billing, more billing. This is the correct. Oh, 74 is correct. 72 lessons. 74 is correct, madam. 74 page correct.
Correct.
Correct. Yeah.
74 is correct.
The Gazette teacher, my lord.
Sarma, there is apparent contradiction in the stand taken by the respondent number 2 and 3 in their affidavit with the page number 74.
Page number 74, yes, madam. That was the revised pay scale 2007, and it was not spent here. 2007 is remained here. Earlier it was 2,500, then 2,300, then it was 2,700. And it was also there, madam, no spent. 2,700 also there.
No,
Yeah,
but
the
you
Gazette
see,
was-
this is the Gazette notification. This is the 74 is the Gazette notification.
Yes, madam.
And this page number 113 and 122 also. This is of dated 9/2/2011.
Yes.
Which one is correct?
Madam, it was filed notification, the gate pay was revised and it was remained continue, my lord, in the Assam Gazette also, 2,700.
Here 2,700 is the graduate grade pay of graduate teachers.
Yes.
Teacher, my lord, the graduate teacher with intermediate skill, my lord.
How?
Yes, my lord, in page number 91, paragraph 7. And the affidavit in opposition filed by the respondent number 3. That your deponent begs to state that there are graduate teacher post and intermediate teacher post in ME, MB, MEM school, and both are entitled to enjoy pay scale in 7-2. But grade pay at the rate of 2,700 was paid to teachers appointed in the post of intermediate teacher who had graduated with diploma in elementary education. And grade pay at the rate of 3,300 was paid to the teachers appointed against the postgraduate teachers
till 31/3/2016.
So, whether this statement in paragraph number 7
Yes.
is inconsistent with the page 74?
The impugn order.
It was and before 31/3/2016. And thereafter, this was come, my lord, this Assam Gazette was come. It was 2016. And grade pay and the rate of rupees 3,300 was paid to the teachers appointed against the postgraduate teacher, post of graduate till 31/3/2016. As per Assam Service Division of Pay Rules. And thereafter, the Assam Service Division of Pay Rules 2017 came into force with effect from 1/4/2016, whereby graduate teachers working against graduate posts of higher and higher secondary schools as well as the teachers of ME, MBA, MEM school, irrespective of graduate posts or intermediate posts have been allowed to draw grade pay at the rate of 8,700 under pay band 14,000 to 49,000, provided the ME, MB, MEM school teachers must be 10 graduate or a graduate degree with diploma in elementary.
But this is scale of pay mentioned in the paragraph number, no, page number 74 is graduate teachers with effect from that is March 17 of 2017. Which one is correct? And you show the document, Mr. Sharma.
Madam.
What are the documents you have enclosed to support your contention is paragraph number 6 and 7?
No, next in the document.
So where do you got it?
Is, I have.
It is apparent contradiction with the page number 74.
I have found this. Madam.
My learned friend,
Required, madam.
my learned friend give,
Assurance or regarding the sure whether it is certain or non-minor finance is also required, madam.
No.
my lord, para 7, I have replied, my lord, 102, my lord. Page number 102, in my reply, my lord.
Let him obtain instruction.
My
Heard Mr. Bora, learned counsel for the petitioner.
Madam,
Mr.
finance also required here.
No, this is,
Mr.
I'm not praying for the
You saw
financial
learned
benefit.
extending counsel for the respondent
I'm
in
not praying for
secondary
financial
education
benefit.
department. During the course of deliberation, attention of this court was drawn to the page number 74, wherein it is stated that graduate teachers with pay band 2 is entitled to scale of rupees 5,200 to rupees 20,200 with grade pay of 2,700. But no, and this graduate scale has been published in the Assam Gazette Extraordinary March 17, 2017. And this scale, this page number 74 appears to be contradictory to the stand taken by the respondent number 2 and 3. The respondent number 2 in the affidavit in opposition dated 12 of November 2024, especially to paragraph number 6 and 7. 6 and 7. And in that view of the matter, Mr. Sharma, learned standing counsel for the respondent in secondary education department, is directed to produce relevant document in support of the contention being made in paragraph number 6 and 7 on next step. list the matter after vacation.
May it be taken up as a part head matter.
Okay, as part heard.
Much please. I will be allowed to correct in my document. But- Okay, thanks for continuing.
Just one apologies, madam. In the previous matter, before this matter, madam, the record which I am giving, and I've just gone through the notification which we had, the petitioner given. The notification of the concerned department, which should also be record. I've given the copy of the notification, madam. That part I have not seen because that time just been given me. I've gone through it, my lord. I've marked it. And on that part, I just wanted to point out, we lordship will consider this point also. That second part, my lord, mark it there. That they shall also ensure that the currency of the suspension order. That's what got it, madam. They shall also ensure that the currency of the suspension order could not extend beyond 3 months if within this period the memorandum of charge or charge sheet is not served upon the delinquent. If the memorandum of charge sheet or the charges is not, the charge sheet is not served upon the delinquent, then it has to be extended before 90 days. So in my case, my lord, 90 days is before 90 days is 90 days happened at 8/10/2025. We have my lord, we have reviewed it, my lord, on 4/10. Therefore, it covers my case as per this order. This I had not seen it. Now I saw it, my lord, when he gave it to him. So it actually, the first part is different, my lord. The second part, your lordship, will notice. I have marked it. They shall also ensure that the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent. So in my case, my lord, he said that I have not served the charge sheet. Prior to the review, I have served it, the other charge sheet. So my case covers them. So before 90 days. 90 days happens that.
No, the question is whether you have filed a search sheet within 90 days.
90 days, no, in this matter, 90 days happens at 8th of October 2025. So prior to that only we have, my lord, reviewed it. That's what they have said. They shall also ensure that the currency of suspension order shall not extend beyond 3 months. So we have reviewed it. And if, my lord, and they have given here, if within this period the memorandum of charges / charge sheet is not served on the delinquent employee. So by what notification he has given, that only I am suggesting. The lordship will take it to the.
Okay, we'll see.
Because this is the crucial one.
Item number 7.
Please, Your Lordship. Your Lordship, Mr. KR is on leave till the 12th of December, Your Lordship. The matter may be taken up after 12th December, Your Lordship. Our affidavit has been filed with us.
Okay, after 12, heard Mr. Huck, learned counsel for the petitioner. Ms. Upadhyay, learned counsel appearing on behalf of Mr. S.C. Kyle Saminster. Mr. Kyle is on leave till 12 of December.
Yes, Your Lordship.
And press for listing the matter after 12 of December. They are allowed. Ms. Bora for respondent number 6. List the matter.
On 19 January.
Major interim order passed earlier.
Interim order passed earlier shall continue.
Therefore, hearing under order 41, rule to CPC. Item number 8.
May I please, Your Lordship? The exact, I could not trace out, but I'll try to. Section 34 with regard to the partition, so I tried my best, Your Lordship. But apart from that Lodhi's case, which I had faced earlier, Ibrahim Uddin's case. I think it will not be there in the record of the.
Ibrahim?
The original landowner, she expired. If I may take your lordship to the plaint, which is at page 30 here.
No, you have already taken me through the plaint earlier. But which judgment you have referred now?
That Ibrahim's judgment, your lordship. I think it was given, but it was returned back to me in the last occasion.
Okay, you file it then.
I just there. Your lordship had written that same.
No, okay, you file it.
Yes, your lordship. Page 50, para 54, your lordship. Sorry, not para 54. It is with regard to section 34, proviso.
Okay, specific relief.
Page para 55, your lordship. Because for that purpose, I would like to take your lordship to the plane. Because the consequential relief of partition was not sought.
Okay, paragraph, sorry, section, specific relief act.
Section 34. The proviso to the section 34, the consequential relief. Because in this particular suit, the parties are claiming themselves to be descendant from a single source, being the legal heirs of late Nanka.
But the question is whether they should include the partition also.
Because they have, if your lordship sees that in the declaration at page 36, they have sought for, they have only sought for, though they have admitted that the defendant number 1 was one of the legal heirs of, if your lordship, first of all, may kind to page 30, the plaint. If your lordship finds the plaint, which I have annexed at page 30.
Yes.
Then I will take your lordship to the relevant part at page 32. Para 3. Para 2 and 3. Number 3, that late Nanka Satnani, wife of late Ram Satnani, the mother of the plaintiff and the pro forma defendant, and also the mother-in-law of the defendant number 1, was the original owner and recorded patadar of the suit land. So what I'm trying to say is, your lordship, it is an admitted position that the defendant number 1 who sold the land to me, I'm the appellant who is the defendant number 2 in the main title suit, your lordship. I was sold some plots of land by the defendant number 2 in the plaint, in the suit, and that sale deed was challenged by the other legal heirs, also claiming right title and interest, and at the same time sought for an injunction restraining the seller and me not to enter the suit property. Now, once that was there, the only prayer they have sought for is for declaration of right title and interest, but at the same time, the consequential relief of partition of the suit land, because it cannot be denied. Under section 44, I am a co-owner. Section 44 of the TP Act clearly says that a sale by a co-owner is permissible to the extent I have a share. Now, once they are challenging the sale deed, the right of me, when they have admitted me as being a legal heir of the person who was the original sale owner of the land, the consequential relief of partition.
You are referring to section 44. Section 44.
Just The right of a co-owner, your lordship. Transferred by one of the co-owners. Now, if your
You are
lordship comes
referring to
to section
section?
44 of the Transfer of Property Act. Because the sale deed undoubtedly is executed by the defendant number one, who is admittedly the legal heir of the original landowner, along with the plaintiff and pro forma defendant. Now, I'm not a stranger. Now, once that is there, if your lordship sees the provision transferred by one co-owners, when one or more, two or more co-owners of an immovable property legally competent in that behalf transfers his share of such property or an interest therein, the transferee accrues to such share or interest, and so far as it necessary to give effect to the transformer's right to joint possession or other common or part enjoyment of the property, and to enforce a partition in the same, but subject to considerations, etc. Where the transfer, this is the main thing, your lordship. Now, my share will have to be determined before the sale deed has to be cancelled, because my right to sell is not defeated, because I have a right to share. It is also admitted that I am a person, because the person who sold the land to me is a legal heir of the original owner of the land. And so, while seeking a declaration of the right title and interest, the consequential relief for the partition as to demarcate as to how much each of us are entitled to has to be first determined before cancellation of the sale deed. The sale deed got cancelled without first determining the share of the parties. This is one of the issues which I had raised before your lordship.
Okay.
And section 34 clearly says the consequential relief is not sought for, because this is a vital issue, because the main relief is cancellation of the sale deed. On one hand, they are admitting my right over the land, and secondly, they are seeking for cancellation of the sale deed. But the consequential relief, my only thing that can come into their benefit, that if I sell excess land. Now, excess land will only be determined when the suit land is partitioned out. But that partition is not prayed for anywhere. So my submission is the proviso of section 34, that consequential relief was not sought for, comes into play in this instant case, your lordship. Because section 34 of the specific the proviso to specific relief act clearly lays down that.
So you come to your memo of appeal, where you have suggested the substantial question of law
Yes,
on
your-
this point.
In this, your lordship will find with regard to your para 5, substantial number 5 deals with the partition part, your lordship. At page 6 of my memo of appeal, that in view of the fact that the respondent having only sought declaration of the right title and interest over the suit land, which originally belonged to late Nanka Satnami, who were the parents of the respondent and husband of the pro forma, without having sought for further relief of partition filed by this respondent, was hit by the proviso of section 34 of the specific relief act. This was my issue which I had framed, your lordship.
Heard Mr. Biswas, learned counsel for the appellant. Argument concluded, order is that it is.
It's time for orders.
I do oblige, your lordship.
I think in this case, they have supposed to place information.
Earlier, it was sent to Communication Department of for pending, and now Department has suggested for modification matter. That is my.
Modification regarding?
Madam, here. I am directed to inform you that as I informed earlier, the draft minutes are proposed to be verified by the education department has already been received by this department now after suggested modification. The same is being endorsed to the other department for further necessary. Time may be granted so that I can get the update.
When the order was passed? When?
28/4/2023.
23. And how much time you want?
Otherwise, 2 weeks may be granted, my lord. So that conclusive result may come out, madam.
Okay. Let the this secretary with the conclusive result remain present in the court
Madam,
next day.
as last chance, madam.
No, no. Enough is enough. No last chance.
Madam, already process has
Heard
already been
Mr.
taken, madam.
P. Sharma,
And as per judicial.
Learned Counsel for the
Judicial
petitioner,
department suggestion, my lord.
and Mr. U. Sharma, Learned Counsel for the contender. Today, Mr. Sharma has produced one letter dated 2nd of December 2025 of the Secretary to the Government of Assam Department of School Education. Then he submits that the department has already received the draft minutes proposed to be vetted by the Judicial Department, and some modification has been suggested, and the same is being endorsed to the other department for further necessary action. And he prays for granting some time to convey the final update. Final update. However, having gone through the record, I find that sufficient opportunity has been afforded to the contender to comply with the direction issued by this court in the WPC number
28/4/20.
7175 of 2022 by the order dated 28/4/2023. Now to comply with the order dated 28/4/2023 passed in WPC number 7175 of 2022. Accordingly, taking note of the aforementioned facts and circumstances, it is provided that the contender shall remain personally present before this court with the final update on last therefore last 15 December.
Finally, 15.
The
Lordship.
letter produced before the court today shall be marked as Annexure D and be tagged with the record.
So, Lordship, on 15, I have some problems, Lordship, my ritual function, so kindly accommodate some other details.
70.
Lordship.
70%.
Next one.